All right, ladies and gentlemen, there's still a bunch of people signing in. Let me give them a moment. Okay. All right, I'm going to begin with Lasa County civil dockets. I'll ask for announcements from the attorneys. Anybody who is present, who you either don't have an attorney or your attorney hasn't made it onto the Zoom meeting, please make sure I know that you're here. But otherwise, have your electronic device muted. The matter of the marriage of Patricia and Michael Rodriguez. All right.
I'm here, sir. Michael Rodriguez.
All right, and do you have an attorney, sir?
Yes, sir. Ms. Flores, I think she's logging in here in a little bit.
All right. Okay, I'll mark you present. All right, Shannon Luber, Patricia Rodriguez, I'll recall. Atascosa, San Miguel versus Peeler. How long was the announcement?
Your Honor, Jennifer Friel for San Miguel. We have 4 items set for today, and I expect at least an hour per item. So on the safe side, we're looking at 4.5 or 5 hours.
Okay.
Your Honor, Mark Guthrie, Kiewit Mining Group. I agree with that.
Okay, I'll mark you 4 hours and let's see how much time we have. I need to let everyone know that I have a hard deadline at 3 o'clock this afternoon. We have a meeting with the new public defender's office that's being set up, and there's a board that works with them, and I have a meeting with that at 3 p.m. All right, Karnes County, in the matter of the marriage of Gianna and David Morales and David Cantu.
Judge, that case has been dropped and it's reset to January the 14th.
Thank you.
And there was another Atascosa County case, Judge. Jesus Villa and Troy Capital.
Oh, I'm used to it. Okay. Jesus Villa versus Troy Capital versus Jesus Villa.
I'm here for the plaintiff, Your Honor.
Okay, and this is a default.
Yes, sir.
All right, I'll mark that. Wilson County, 15-6-359, in the interest of PRS, a child.
Case has been dropped, Judge.
In the interest of Presley and Bowen Ivy.
Yes, Your Honor. Jeffrey Bernstein for the movement, 2 hours on temporary orders with a motion to interview.
Your Honor, I believe we're here on temporary orders. I think that the court normally has a 1 hour. I would like to confer with opposing first.
Okay, I'm going to ask the attorneys to confer on this, and we have local rule limits orders typically to 60 minutes. I'm going to make Ms. Riley the host so that she can be in charge of breakout rooms.
It's not highlighted.
Navarro Production Joint Venture versus Andrew Affel.
Judge, that was set in error. I apologize. It's not on the docket. It shouldn't be on the docket.
All right, the matter of the marriage of Rawlings, that was disposed of yesterday.
That is correct, Judge.
19-5-386, in the interest of JM, DG, and PG children.
Your Honor, you said that Rawlings was disposed of yesterday?
Yes.
I'm the attorney on that. That was set for today.
Today was for a motion to withdraw.
Yes, we don't have, I need an order on it. There's been no agreements. I haven't dropped it.
Okay, and who were you representing, Michael Rawlings or?
I was representing Shannon Rawlings. It's a motion to withdraw. There's been a division. 5 minutes is my announcement, Your Honor.
All right, just give me an order. I signed the final decree yesterday with Rachel Reuter as the attorney, so.
Oh, okay, we're just doing it for ethics reasons, or in another firm, that's why.
That's fine, okay. All right, and the announcement in the interest of JM, DG, and PG children, 19-5-386.
Moving's present, Judge. I have a motion to terminate wages withholding and for child support arrears. I think we're going to have an agreement, but the respondents are pro se, and the Attorney General's office is also involved.
And
15 or 20 minutes.
Edward Balderas for the Attorney General's Office, Your Honor. I agree with that announcement.
Okay, and I believe that the Martina, is it?
Gonzalez's.
Yes, we're here.
Yeah, they've told me they're in agreement,
Wilson
Judge, but I
County,
can't, I
yes?
need to get them to sign the orders.
All right. Well, I'm going to ask Ms. Riley to put all three of you in a breakout room in a moment.
Yes, sir.
The matter of the marriage of Lana and Randall Bass.
Your Honor, that's another motion to withdraw, 5 minutes.
Marking number 2. Matter of the marriage of Jarrah and Rashid and Divine Boone, or Devi Boone.
That case has been dropped, Judge. Reset on request.
All right. Matter of the marriage of Cheryl and Dennis Owen.
Mr. Cedeos called our office. He is waiting on signatures. He should have the order e-filed later today.
All right, I'll put order to come. Anyone else told to be here today, your case was not called?
On my motion to withdraw, we did give notice to Lana Bass, who was our client. So if Lana Bass is there.
Okay, all right, I'll recall that whenever we get that case.
Okay.
All right, has anybody appeared in the matter other than Mr. Rodriguez in the matter of the marriage of Patricia and Michael Rodriguez? All right, I'll come back to that. Troy Capital versus Jesus Villa.
Yes, Your Honor. I would ask the court to take judicial notice of the documents filed with our motion for default judgment.
Okay, I'll do that, but it's going to take me a little while to pull up the records from the district clerk there, so I'll work on that.
Okay. In this case, Your Honor, the defendant was personally served on June 25th of 2019. He has still not responded. We have supplied documentation to prove up the debt and the value of the debt. And we're just asking for a default judgment in the amount of $8,788.10 with post-judgment interest at the contractual rate of 20.99%.
Okay.
And attorney fees of $500. I believe we have an attorney fee affidavit on file with our default judgment. If not, I can prove up our attorney's fees.
All right, let me get onto the district clerk's page. And has this case been on the docket before?
It just took us a while to get a hearing, is what I understand.
Okay.
So the basis of the underlying debt, Your Honor, was an auto loan that the defendant defaulted on.
Okay, that's fine. I always want to check. About 10% of the time on these, the person has filed a pro se answer, but they didn't copy the plaintiff's attorney.
Oh.
All right, well, it's not calling it up. Here we are. All right, that looks good. looked at the service members affidavit, and you have your notice of certificate of last known address.
Yes, Your Honor. Did that not get filed? I can certainly get it filed.
I don't see it in the index in the clerk's office. Okay,
I'll have my associate refile it.
okay, I've got the notice of hearing, first amended service members affidavit, notice of hearing. I don't see any evidence, the attorney's fees, anything on attorney's fees. So-
Okay, Your Honor. I bill at $250 an
Hold
hour.
on, do you swear or affirm a testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, I'll take judicial notice without objection that you're a licensed attorney and you're familiar with the attorney's fees in Atascosa County. Go ahead.
Yes, Your Honor. I bill for collections cases at $250 an hour. I've been licensed for 10 years. A significant portion of my practice does involve debt collection. So I feel that the $250 an hour is a fair and reasonable rate. It takes me 2 hours to prepare the petition, review the documentation, attempt service, and attend this hearing. I actually cap my fees at $500 for these cases. So, but I have spent 2 hours on this case, and we're asking for $500 in attorney's fees.
Okay, I will find that the answer has not been filed in this case. The return of service in the proper format's been on file for more than 10 days, and the answer period passed a very long time ago. And I will grant the relief prayed for. Do you have your proposed judgment?
Yes, sir.
If you could post that to me in chat, I will sign it and send it back to the district clerk's office.
Yes, sir. Do you want to just, yeah, there you go.
If you'll just go to chat and my name, you should, or everyone, you ought to be able to get an option that says file and just click on file and you can send it right to me if you have it in a PDF format.
I can do that.
All right. Okay, in the matter of the marriage of Bass, Wilson County?
Yes, Your Honor, I'm present.
Okay.
This is our motion to withdraw. Previously, I don't know if other associates have come up to you yet, but I'm from Bendowski and Butler now. There was a previous division of the firm. Ms. Reuter was a previous partner of our office, and she's gone off on a solo adventure, I guess. And as such, you saw her yesterday for that final divorce decree, but for liability issues, we need to have an order to withdraw signed by the judge, just removing us officially from the case and as representation from the client. We have noticed Ms. Reuter's firm and her client. With my motion to withdraw, there was a release filed as an exhibit where the client was stating that she is moving with Ms. Reuter's firm and that she just discharges us. But we still need an order signed on the matter.
Okay. Do you have your proposed order?
Yes, Your Honor, I do.
If you'll post it to me in chat, I will sign it.
Thank you, Your Honor. Your Honor, previously you had said on the Rawlings case, which their final divorce decree was signed yesterday, that you want it just in order. Do you want them in two? Oh, I'm putting it in the chat. So you want me to put that order in the chat as well?
Sure.
Okay, thank you.
All right, I'm going to have to. Ms. Benavides, my computer and or Zoom are playing the game again where it shows I haven't filed any documents, saved any documents in my Atascosa County docs file for several months. So I can't post this order to you in chat. I just sent it to you by an email.
Okay.
All right, so that's in the Troy Capitol. Mr. Hardesty, that's been sent to the clerk's office. Give me just a moment and we'll get to the Wilson County cases.
Thank you, Your Honor.
Okay, and same thing on the Rawlings case. I can't load it into Zoom, but I just emailed it to Ms. Kruger.
Okay, I will submit those through e-file, Ms. Scrubs.
Okay, thank you.
All right, I have here, Ivy, you've announced 60 minutes. Let me ask the attorneys in the Peeler case, have I been given do I have a Dropbox link or something for all of your documents for today?
Yes, Your Honor. Would you like it in chat?
Sure. And then I'm going to ask you to come back at, say, 11.
Thank you, Your
Fine,
Honor.
Your Honor. Thank you.
And before you go, I did not get it completely written up yesterday. I am in the process of writing up an order on the 2 motions to exclude from yesterday. In a nutshell, what they're going to say is, I don't like either of the positions I'm being asked to choose between. Having been in this position in the past and having tried to craft some other third answer and deciding that having 2 sets of very skilled lawyers attacking my work on appeal was worse than having 1 set of very skilled lawyers attacking it and 1 set defending it, that I wouldn't do that again. I'm going to say I'm not going to do that again. But I am going to ask the attorneys to go back or to look forward and start working on your proposed language for what you want the jury charge to say on this question of damages. Because with the way I see it, I'm being asked to choose between the San Miguel having a duty, both contractually, which perhaps could be, said to be accord and satisfaction if there's a suit over the land hasn't been restored and we want the money to restore it. But there's also the regulatory duty to do it. So it looks like I'm being given a choice between a windfall for the peelers because they get the cost of restoration, plus they get it restored free, plus they get the difference between the restored price or the restored value of the land and the I guess the stigma value damages. And I'll say that I will allow some sort of stigma value damages. I don't see that any differently than when someone causes an automobile collision. Sure, you can fix the automobile, but I've been in that position where you walk in to trade your car in and the first thing the salesman says is, hey, well, you've had this fender repainted. It must have been in a wreck. We're going to knock some money off. So I think stigma damages, it's appropriate to at least let the peelers make the case whether there are stigma damages or not. On the other side, the defendants are wanting to, San Miguel is wanting to just say, well, we're just going to blithely assume that all sorts of reclamation will be done in the future and base your damages, if any, on that number. And I'm not comfortable doing that either. But if it turns and I'm going to let y'all come back at 11. I just want to let you know. So if the witnesses today, I have no idea who they are or what they're about. If they're somebody or any of them are something that would be affected by that written order I have coming, asking the attorneys to give me language on what your proposed jury charges are going to be so I can know exactly what you're going to be asking the jurors to decide so I can see what's relevant with the testimony you're both trying to exclude.
I think there is some argument today, Your Honor, that will help on this issue to explain that the reclamation that you're concerned with is happening on the leased property and the restoration we're asking for is on the non-leased property. So that if there is reclamation that will occur in the future, that's not actually that's not double counting what the restoration would be outside the leased area because there's no duty there.
And then my question is, did your damages expert segregate out the leased and the unleased? But again, I'm gonna get on with the family law case. I will see y'all at 11. I just, in case that I didn't want to say that at 11 and then have you say, oh, well, then we don't need a hearing today. We need to go work on that. So if we still need a hearing today, I'll see you at 11. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
All right. All right, Mr. Bernstein, Ms. Nettles, what's going on with the Ivy case?
They're still in a breakout room, Judge.
Oh, okay. All right. Okay, I'm going to set a timer for 9:45. If we haven't heard back from them by then, I will ask you to go in and interrupt them. And I'm going
Yes,
to
sir.
start working on all the other things I've got to work on.
And on the Rawlings case, that was the order of withdrawal was granted, Judge,
Yes.
as well as the Bass case.
Well, I've only gotten I don't think I've received the order on Bass, have I?
Okay.
Yes, it's in the chat, Your
Oh,
Honor.
I have. It's up here too. Okay. And now I go to see if I can post this in chat, and this order is there and the Rawlings order is there, but I had to email because it wasn't visible a few moments ago. So I just sent that to Ms. Kruger, so she has it to e-file. All right.
Yes.
Groves.
Thank you, Your Honor.
And are the attorneys still conferring also in the Gonzalez case? Looks like it.
Yes, I believe they are.
Yes, Judge, they're in a breakout room as well.
And Ms. Embry, who are you with?
I'm here with the Ivy case. I'm Presley and Bowen's mother.
Okay, all right, thank you.
You're welcome.
And Mr. Rodriguez, have we heard anything from your attorney or your wife or her attorney?
Sir, I think Ms. Flores, my attorney, she's on the criminal docket, I think.
Okay, so she needs to answer over there.
I
That's
think
fine.
she's representing somebody else. Okay, sir.
That's fine.
And this is Patricia Rodriguez. I am present.
Okay, I'll mark you here and we'll wait for the attorneys.
I do not have an attorney. I had contacted one and he is having some medical issues and has not been able to get back with me. So I wanted to ask if I could have it reset.
Right now, it says here that your attorney is Shannon Lubar.
She is the attorney for the Attorney General because my ex-husband's attorney wanted it moved to district court for the, I guess, modification.
Okay.
Because there were other issues in our case.
All right. And Elizabeth Martinez is the county attorney?
She was my divorce attorney 3 years ago. She hasn't practiced in 2 years. She's now a judge. But Ms. Flores had added her whenever she did the first motions. So I'm assuming that's how that showed up. But I had been speaking with Eduardo Pena out of Laredo in regards to my case.
Okay. And was your name changed in the divorce? Is it still Patricia Rodriguez or is it Patricia Tinnery now?
It's still Patricia Rodriguez. I haven't changed my driver's license or my social security card yet.
All right, ma'am, I will mark you as representing yourself on the docket. I've taken Elizabeth Martinez off. And I'm going to ask you to remain online. Let's wait for Christina Flores. I'll take your I'll consider your continuance, but let's see if this is something that you would be able to work out today.
Okay, thank you.
If not, then by all means, we'll wait and come back with an attorney. So this is not a divorce. It is your divorce is finalized, is what you're telling me. It's just a matter of the interest of the children.
Yes, sir. Yes, sir.
All right, and you're in agreement with that, Mr. Rodriguez?
Yes, sir.
Okay. All right, then we'll wait to hear from your attorney. Thank you.
Judge, on the Bass order to withdraw, I don't
Yes.
see your signature on the document when I pull it up.
All right, maybe that's the copy before I signed it. Yeah, there's nothing in my Wilson County cases. All right, I will email that to you right now.
Okay, thank you.
Judge, I believe both parties in the breakout rooms have come back to the Zoom meeting. Other than the person that was in the Wilson County District Clerk's guest room, they're still on breakout room 2.
She's trying to get out. I think she's just not sure how to do it. That's Ms. Gonzalez's pro se.
Okay.
All right, give me just a moment. Okay, Mr. Bernstein, Ms. Nettles.
Judge, we have a chance to confer, and where's Ms. Nettles? There she is.
Here, Your Honor.
And we had a question for you. If I think we need to talk to you in a breakout room.
Okay, let me ask Ms. Riley to move us to a breakout room. All right, Ms. Riley, did you hear that?
Judge, I'm sorry, I did not. I was.
Oh, okay. Jeff Bernstein, Teresa Nettles, and I need a breakout room.
Oh, okay. I'll put them. And yourself?
Yes.
Okay.
Okay, Ms. Riley, I'm going to ask you now to set up a breakout room for Lachey and I and for Tiffany Embry. And Ms. Embry, Teresa Nettles is your attorney? Okay.
Yes, sir.
All right. The attorneys want me to meet with Presley Ivy. Presley is 12 or older?
Yes, ma'am. Yes, sir. She just turned 12 in September.
Okay. All right. So I need to meet in a breakout room with my court reporter and with Presley, but Presley has to be alone and not with you or anyone else. So is that?
That's fine. She can go. Is her bedroom all right?
That's great.
Okay. Would you like me to take you there now or?
Sure.
When we
Just take the computer or however you need to do it because you're going to get an invitation to a breakout room.
Okay.
All right. And let me ask for what announcements do we have in the 19386 case?
Judge, we need about 15 minutes of the court's time. I think we're in agreement on the substance of what we're doing. The question is how to get orders signed.
Okay. I have to go to a breakout room in a moment, and then I will come back while the attorneys are conferring.
Yes, Your Honor.
Judge, it's yourself, Lachey, and then Tiffany Embry. Is that correct?
Yes.
Okay. I'm going to put y'all in breakout room 3.
Can I get Marilyn Ivy added as well? I'm the dad. I'm on Marilyn's deal because I got a bigger monitor here.
Who are you?
I'm Kevin Ivy. I'm Presley's father.
Okay. No, sir.
Okay.
Mother is not going to be in there. I'm just going to be speaking.
Okay.
So no.
Okay.
Neither one of you.
I thought it was in a different chat room for everybody. Okay, I'm sorry.
All right. And before I go off, Christina Flores.
Good morning, Your Honor. I apologize. I'm before Judge Ellison on my other computer on a criminal matter. We have a plea this morning. And so I stepped away so that I could address this case. I just assumed the same judge was handling civil and criminal dockets this morning. My mistake. May I be placed in a breakout room with Ms. Tenery and maybe I can confer with her? I know she's pro se.
Yes, and she had asked for a chance to hire an attorney.
Oh, okay.
I don't know, and I don't know what's going on. I would certainly consider that, but just in case this is something that you can settle this morning, or at least settle that you're going to wait give her an opportunity to hire an attorney. I'll ask to speak with her.
Okay, Your Honor, if I may, just by way of background, what happened is that the parties divorced on or about 2017, and pursuant to a mediated settlement agreement, they determined that Mr. Rodriguez would pay certain things that continued.
Actually, ma'am, I need to be getting in the breakout room myself.
Okay.
With
Okay.
Trial, so I'm going to ask you just to hold that for right now.
Thank you.
Riley, is that other breakout room coming?
It's coming, Judge.
And Ms. Rodriguez, you should receive a breakout room request to go to a breakout room in a few moments. It should be a pop-up and we need to hit join to join that.
Okay, thank you.
I'm going to the breakout room and I will see, looks like Lachey is beating me there.
Ms. Flores and Patricia Rodriguez, I'm going to put you all in breakout room 4.
Thank you.
Okay, if you could put me, Ms. Riley, back in breakout room 1.
Yes, sir. You said breakout room 1, is that with Bernstein and Nettles?
Yes.
Okay.
Your Honor, may I be heard? Christina Flores.
No, ma'am, I'll be back in a moment. I have to go join the breakout room.
Okay, Michael, you there? Can you see me?
I can see you, ma'am.
Okay.
Hello.
So I don't know why they
Good
put us
morning,
in a
ma'am.
breakout room. I just spoke to Miss Tenery and she's gonna hire a
Mhm.
lawyer. And that I think will actually help us.
Ma'am, you're not in a breakout room.
Oh, I apologize.
I can put you in a breakout room. Hold on one moment, please.
Can you, actually, she's seeking to hire an attorney. Can you just reset us so that she can have time to
Let the
hire an
judge
attorney?
know, ma'am, when the judge comes back.
Thank you.
Do you want the breakout room or not?
No, I'd wait for the court to hear us so that he can just reset us for, she needs time to hire an attorney.
Sure.
Thank you.
I can give you some dates. I mean, are y'all looking at a certain date?
No, whatever you have available.
Patricia Rodriguez, how much time do you need?
I'm not sure because he's dealing with a medical condition, the attorney that I was talking to.
You want to reset it to like mid-January, maybe January the 20th, or maybe the 13th?
Could we do February? Could we do February just in case? I just don't want to. And then if we
Maybe
can,
up to the parties. I mean,
yeah,
Christina
I
Flores,
don't know.
We have no objection. That's okay. February's fine.
February 1st, February 11th. What do y'all think?
11th.
February
Okay.
11th. Okay, so we'll just make that announcement then. If y'all make that announcement, we can reset to February 11th.
Do I have to remain or can I pop back into? I've got Judge Ellison over there on
Yeah, I mean, you can go to Judge Ellison if you want. I can let the judge know, but you might want to just come back just to let him know.
Okay, thank you.
Okay, Ms. Flores, yes, what's going on?
Good morning, Your Honor. I apologize. So I spoke with Ms. Tenery Rodriguez, and she would like to retain counsel. She said her attorney's dealing with some medical issues, and so she's requested we've agreed to reset it to February 11th, if that's okay with the court's permission.
That's fine with me. All right, so we're going to restyle this as just in the matter of the interest of the children, rather.
Yes, Judge, I've updated it.
Okay.
On our system.
And are you seeking, it says motion to modify child support or clarification. So are you seeking any relief that we need to have the Attorney General in here for?
Well, that's initially how we got started, was before the Attorney General, and then I filed a response, and then I filed my own, or attempted to file a motion to modify the terms of the decree. And so that one, for some reason, that my petition did not get processed, and so that'll give me time to refile it for February and I guess confer with the attorneys. But yes, we are seeking to modify the divorce decree.
Okay, so I'll leave the Attorney General's office on here.
I had sent them an invite to this hearing, Judge, as well.
Okay. All right, thank you. Then you are excused, ma'am.
Thank you.
All right, and Ms. Rodriguez?
Yes, sir.
Okay, and you, okay. You heard that you're set for February the 11th?
Yes, sir.
All right, that's more than 60 days out. So if you're going to need an attorney in this case, absolutely, you need to have one by that date, even if the person you've been dealing with doesn't get over their health issues.
Exactly. No problem. No problem. I will contact somebody else to talk with them also, just in case.
All right, then you're excused too. Thank you.
Thank you. Thank you.
Okay, in the interest of JM, DG, and PG children.
Yes, Your Honor.
Okay, what's going on?
Judge, if I can give the court a brief background on the case. Ms. Gonzalez, who's pro se today, originally filed a petition of termination and adoption for her grandchildren in May of 2019. In August of 2019, we had a temporary orders hearing in front of Judge Ellis. He ordered child support to be paid by my client, Megan Gonzalez. The reason the children were with their grandparents is because CPS had a case pending and they had placed them there. Subsequent to that, Judge, moving forward to about January of 20, the children were reunited with my client, Megan Gonzalez. But the petition for termination and adoption is still pending. It hasn't been finally resolved. So my understanding is paternal grandparents no longer wish to pursue that litigation, and they're willing to non-suit it. However, they've never filed a non-suit. They're not represented anymore. Their lawyer withdrew. And I'm trying to get my client's wage garnishment stopped because she's had the kids for 9 or 10 months and she's still getting garnished on her wages. So I filed a motion today to stop the wage assignment. I filed a motion to confirm arrears. And I did the courtesy of sending the Gonzalez's a notice of non-suit and an order of non-suit to try to help them do what they've suggested that they want to do. And I think we've all agreed that there's not going to be any arrears, that my client's no longer going to be garnished, that the lawsuit for petition to terminate and adopt is going to be withdrawn. However, Ms. Gonzalez is reluctant to sign any orders today. And this is the exact problem I've been having for about a year is we can't get orders signed. And so the case just keeps lingering on the docket. And my client keeps becoming subject to Attorney General's sanctions of garnishments and interceptions of taxes and everything else. So today I'll let Ms. Gonzalez speak for herself as to whether or not she's going to agree to non-suit her case.
All right, Ms. Gonzalez,
Yes, sir.
what are you wanting to do today?
Well, I want the original orders that when we went in front of you in January to say, like, you had told me if I don't agree, don't sign it. He knows I don't agree with paying 50% of the medical. They're saying it's a mistake, but still want me to sign it. Fix that mistake and me and my husband will sign it. I agree that the child support needs to stop and, go back to her, but I'm not signing anything
Okay,
that I don't agree with.
Mr. Martinez, you're asking for orders in the future with a grandmother will be paying?
The reason we're not signing that order is because they don't want to proceed with that litigation anymore. She's talking about something that's a moot point at this juncture. She's asking about the final orders in the litigation for the termination and adoption. She says she doesn't want custody anymore. Why would we sign those orders? It makes more sense to do the non-suit if she truly wants to withdraw her litigation. So,
But I thought the Attorney General wanted those papers signed.
Nobody's asking for them to be signed at this point, Judge, is my understanding. There's no reason to. It's a moot
You're just
point.
trying to I feel like he's trying to force me to just hurry up, sign right now. And like those things he sent me last night, I didn't agree with. I'm not going to sign something that I don't agree. I need time to read it, have it looked over, and then I just want to be done. I don't want anything. I'm done. I'm not taking the case any further. I haven't seen the children since you told me to turn them over, Judge. And that's the way I've left. I did everything you told me to do, and that's the way it stayed. He didn't fix the papers, so I can't sign them. I'm not signing something that it says that we're 50% responsible for the medical.
Hey,
We're the
did Mr.
grandparents.
Martinez send you a proposed non-suit?
That's the one you sent me yesterday, Mr. Martinez?
Yes.
Yeah.
Is that just one page that just says that you're non-suiting the case? That means you don't want to proceed with it anymore?
Yes, but it said something on there about being taxed and all this other stuff. And I need to make sure I understand what I'm signing.
There was an order, there was a line in the order of non-suit, Judge, that said that the costs were taxed against whoever incurred them. She didn't like that language. I took it out. But if she would just tell the court whether she in fact wants to withdraw the litigation or not, there's no point talking about orders that become moot if she's in a non-suit.
All right, ma'am. Do you want to proceed with this case?
No, I don't. I'm done.
Then I will prepare an order and dismiss it today.
Okay.
Okay, all right. Okay, and Mr. Bernstein, you wanted to talk with.
I'm sorry, Judge. We also have an order to confirm arrears that if the court will allow the Attorney General and myself to enter the order separately, I don't think Ms. Gonzalez needs to be involved in that if her dismissal is going to be granted.
All right, confirm arrears against your client?
Yes, so they can clean up their records because they have money on hold at the AG's office that my client keeps getting garnished. And once we get an order entered, we can release those monies or whatever they're going to do.
Okay.
Yeah, I called the Attorney General to have this stuff stopped coming to me. So they said they would hold it, that they couldn't stop it completely without a judge's signature. So they said they put it in a holding account. And I did that for her, but I can't stop it, you know?
I understand. So do we need testimony about that, or do you have a proposed?
I don't think we need testimony, Judge. I think Mr. Balderas and I can come to an agreement on it. But just so that I'm clear, Judge, is the court going to issue its own order of dismissal, or I need to submit the non-suit to the court?
I'll sign my own order of dismissal.
Okay, Judge.
But I'll wait until I get your order, just so that I'll sign that and then I'll dismiss it.
I'll confer with Mr. Balderas about that, Judge, and we'll get that order to the court shortly. Maybe
So
not
we're
today,
free to go?
in the week.
Yes, ma'am, you're free to go, and as soon as I get the order on the child support from Mr. Martinez and Mr. Balderas, I will sign the dismissal. I'm glad y'all got that worked out.
And then Martinez, you'll send it to me?
I'll send you a copy after it's been signed, sure.
Okay, but do I have to
Alright.
sign anything on the
No,
dismissal?
ma'am. No, ma'am.
So me and my husband are done.
Yes, ma'am.
Okay, thank you so much.
You're welcome.
Thank you, Your Honor.
Mr. Balderas, can we confer off? the screen?
Absolutely.
Okay.
And Mr. Bernstein, who did you want us to speak to?
I do need Mr. Edward Valderas when he's through with Mr. Martinez. And then Teresa Nettles and I need to go back into a breakout room.
Okay, all right. So Ms. Martinez, Mr. Balderas, if Ms. Wright could put you in a breakout room just so that Ed could stay online so that he can talk to Mr. Bernstein?
That would be great, Judge.
All right, thank you.
Okay, Raymond Martinez and Edward Valderas, you said?
Please, for a couple minutes, yes.
Okay.
Judge, you said I'm good to go? I can leave?
Yes, ma'am.
Okay, thank you so much.
Mr. Martinez, do I need to be present for this?
No, you can go.
Okay,
Thanks.
thank you.
Put y'all in breakout room 6. Mr. Balderas, you should have received something saying to join breakout room 6.
Okay, let me try it. Okay, I got it.
All right.
Judge Wilson, did you see my message on the Bass withdrawal order? That it still came across without your signature?
Yes, let me,
Would it be better if I just printed it and brought it to
no,
you? to sign?
I know I signed it, but it's here without a signature, so. Because I did 2 of them back to back, but I'll send it to you right now.
Okay.
Okay, and did you have a report for me or an announcement? Ms. Nettles, Mr. Bernstein?
Judge, we're just waiting to go to the breakout room.
All right.
I apologize. I just sent them a message. I wasn't sure if they needed one. I'll send them in there now. Just Bernstein and Nettles, is that correct only?
If you can send Mr. Valderas, if he's through, I just have a quick question for him on a case.
Okay.
I'm available. I'm available. I can go.
Okay.
All right. I'll send y'all to breakout room 7. Judge, I'm going to step away from my desk for just a moment.
Go ahead. All right, Ms. Riley, I need to step away for a few moments. I'll be back and I'll still have my computer, my Zoom minimized. If the attorneys come back on the Ivy case, please let me know once I get back. Thanks.
Yes, sir, I sure will.
All right, I'm back.
All right. Nettles and Bernstein are still in their breakout room, Judge.
Thank you. All right, Ms. Riley, will you put me in a breakout room with Mr. Bernstein and Ms. Nettles?
Sure, I'll add you to room 7, Judge. You're muted, Judge, if you're talking.
I need to recall that I'm automatically muted when I come back from a breakout room. Okay. Ms. Nettles and Mr. Bernstein are still conferring. They said they have an agreement very shortly. I have not looked at the documents in this case yet, so I'm going to go ahead and download them and start looking at them and wait for the Bernstein and Nettles to come back. And as soon as they get their agreement read into the record, we'll start the hearings here. Okay, I went and downloaded the 4 zip files that looks like Mr. Schneider uploaded yesterday to app.box, and it will not unzip the first 2. It says that the file names are too long. I assume that means that Mr. Schneider has a Mac or somebody does?
Your Honor, I'll reload and shorten the
Okay.
names for those and then provide an additional link via chat for you, Your Honor.
Okay, thanks.
And those were the folders 1 and 2, you said, Your Honor?
Yes.
Yes, Your Honor, I'll do that right now.
Your Honor, would you like us to suggest an order of the hearings? I think Ms. Friel has asked to hear the motion for summary judgment on the tort with respect to the regulatory standard, and we'll agree for that to go first.
Okay, certainly.
Thank you, Mary.
And do I have the motion for summary judgment? Okay, that's number 2. Yeah, it's some of the ones I can't open yet. All right.
The next motion we'd ask to be heard, Your Honor, is the motion to exclude exhibits and testimony on ash removal and landfill. We think that's related to the motion for summary judgment being heard today, and also the issues Your Honor has raised with respect to Mr. Bolton and Mr. Schultz's appraisals. And then if there isn't time to hear the other 2 motions on Donahue and Zulu, we can either move those to next week or January.
Yeah, our preference is to do the experts first and try to get through all the experts. If after Monday, we should be through with those, and we can turn to, if anything gets bumped, and hopefully nothing will, we can turn to this evidentiary issue after that.
Okay. All right, we'll give, for those of you who came back in late, we're waiting for Jeff Bernstein and Teresa Nettles to come back and read an agreement into the record. I'd like to look at the motions first, but if we don't get that going pretty quickly, we'll go ahead and start and just stop whenever they come back in. Okay, here they come. All right, calling in the interest of the Ivy children.
We have an agreement to put on the record, Your Honor.
Yes, Your Honor.
Okay. All right, go ahead. Or let me ask, are both sides ready?
Yes, Your Honor, we're ready.
All right. Go ahead, sir.
Your Honor, regarding the motion for temporary orders, the parties have agreed to the following, that, and let me get the names right, that the parties will be joint managing conservators with neither one being primary during the temporary orders, that they will share the children week on and week off. Regarding tonight, Mr. Ivy will maintain his possession time that he's had under the old order, and then the children go back to the mother. Then on the 13th of December, he will have the children through the 18th. The 18th, which is next Friday, mother will then have the children through noon December 28th as her Christmas possession. However, as per the old order, my client, as well as his ex-wife, depending on who had the children, he will have the children from Christmas Eve from 2 p.m. to 8 p.m. After the 28th exchange takes place, Your Honor, my client will then have noon December 28th all the way up until January 10th, because we're going to do the week on, week off, starting January 10th, 2021 at 6 o'clock, alternating week to week until either we have a final resolution or until someone sets this for a final hearing. Regarding child support, Your Honor, My client, under the old order, was ordered to pay child support starting January 1, 2021. Neither party will pay child support, and Mr. Ivy's child support will stop. I will send an order over to Ms. Nettles stopping wage withholding. That way he can give that to his employer. I believe that is the agreement. I will say, Judge, that Miss, and I'm sorry, I think Embry's time period with the children, that she will not be required to take the children to the stock shows, and she will not have to take the children to the 4-H meetings.
And Your Honor, just for clarification, in the prior order, it said that he can go ahead and pick up the children. And I'm sorry, and I think that Mr. Bernstein said January the 28th until the 10th, but I think it was December 28th, just making sure that there wasn't a month thing in there. But as far as the stock shows, the previous order stated that Mr. Ivy would be picking up the children and taking them during her periods of possession. That would be stopping at this point as well. And the stock shows would not be during her periods of possession unless she registered them or enrolled them into the stock shows during her periods of possession.
All right, and do you want to have your clients say anything, or you're good with just the attorneys for right now?
Your Honor, I would prefer for my client to go ahead and acknowledge this agreement, and if there's any clarification that she would need for us to have that right now.
Okay, let me ask the parties to raise their right hands. And Mr. Bernstein, your client is on, I believe, too?
I see him coming on right now, Judge. Well,
All right, each of you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. Go ahead, ma'am.
And Miss Embry, is there, you've heard the agreement between the parties. Are there any clarifications, or are there any issues based on the agreement that was set into the record?
The only clarification that I would like is the week of the 28th, that would be Kevin's week of Christmas. And then that following week of the January, that is 2 weeks in a row. Is that correct? Or is it back and forth?
The reason for that would be that would be the normal Christmas break. And then we just made it until the 10th in order for us to make it into the Sunday week on, week off.
Okay. Okay. And as far as 4-H and that, that they won't go on those Tuesdays for 4-H meetings and stuff when they're here at my home.
Correct.
Okay.
Mr. Ivy, did you hear the agreement we dictated into the record?
Yes, I did.
And are you asking the court to render it as a judgment as of today's date?
Yes, I did.
Thank you, Judge.
All right, is it a final order then, or just temporary orders?
Temporary orders, Your Honor.
All right. Okay, anything else?
No, Your Honor.
No, Your Honor.
Do we need an entry date?
No, Judge, I'm going to get this over to Ms. Nettles real quick.
All right, then, I will find the order in the children's best interest, and I'll approve them, and you are excused. Thank you.
Thank you, Your Honor.
And it's approvement for a temporary order, correct?
Yes.
Thank you, Judge.
Thank you, Your Honor.
All right, I see I just got a message from Mr. Schneider. I went ahead, I was able to not use the zip feature and just download these orders one at a time. And I was able to get a hold of them that way. All right, give me just about 5 minutes to read these over and the response, and we'll get started. Ms. Cavazos, if you need a break, we'll give you a chance to. Okay, I'm back. And I take it, Ms. Friel, you're going to present this motion?
Your Honor, if we're starting with the motion for summary judgment, Louis Sutherland for San Miguel, I'm the one that will be arguing the motion.
Oh, okay, all right.
That's correct.
Okay, are both sides ready on that? I don't see, there's Ms. Whittle. Okay. All
Yes,
right.
Your Honor, I'll be arguing this response.
Okay, all right, go ahead, Mr. Sutherland.
To begin with, Your Honor, the moving parties also filed objections to some of the Peeler's summary judgment evidence. There were a couple of expert affidavits that were included with the summary judgment evidence. Generally, the objections are that those expert affidavits are untimely, that they contain new opinions that were not disclosed as part of the case management order for expert designations and opinions in this case, and they're also irrelevant. The substance of that motion, KMG is going to present, and to the extent you want to hear those evidentiary motions today, with your permission, I would like to just defer that to KMG when they have their time to talk, if you want to hear that, if that's okay.
Certainly, certainly.
Okay. And so you've heard about the arguments about state action levels and their implications to the tort claims in this case a number of times already, Judge, in the context of whether or not certain of the Peeler's experts' opinions are admissible or not. Much of the case law that we're going to talk about today is the same, but the context is different because this is a motion for summary judgment. And I think it's helpful as a framework to lay out for the court. We're really asking you two questions here today, Your Honor. The first is a purely legal question that can be decided on summary judgment, and that is for a statutory or common law tort based upon the presence of alleged environmental contamination to real property, is the threshold for a legally recognized injury defined by the exceedance of an applicable state action level established by one of the Texas environmental agencies. So it's a pure legal question that goes to both statutory torts and common law torts as to whether or not these action levels set by the environmental agencies are the minimum threshold to show an injury when the plaintiff is alleging a tort injury arising from an environmental contamination to real property. So that's the first issue. And then the second issue is, assuming that the answer to the first question is yes, have the Peelers presented summary judgment evidence that overcomes a no evidence summary judgment motion? And I think, those two issues are obviously related, but they're distinct and could even have different answers. So for the first question, that question is answered by the San Antonio Court of Appeals in an opinion called Taco Cabana v. Exxon, which the site is 5 Southwest 3rd, 773. Taco Cabana is directly on point in establishing that state action levels represent the minimum threshold for a tort under these circumstances. It's from this circuit. Its petition for review was denied by the Texas Supreme Court. It's over 20 years old at this point. There's no case law out there that's narrowed it or overruled it. And there are a number of cases, as we'll go through, that have actually adopted that analysis of Taco Cabana that fully cover the factual circumstances that are at issue here. And most recently, in 2011, the San Antonio Court of Appeals in the Easy Mark cases readopted the standard as the tort standard under these circumstances. With respect to the second question, whether or not there's an exceedance of state action levels is an expert question, Your Honor. It's a scientific question that has to look at whether or not the concentrations that are present, whether they're above or below a standard that's set by the Texas environmental agencies. And so we'll be looking at the Peeler's expert evidence, and their expert evidence are geared towards a standard for contamination that's based upon alleged exceedances of background. And we'll show that the Texas environmental agencies have specifically said that that's not an appropriate threshold to determine contamination under the state action levels that are applicable here. And so what's happened and what the expert evidence shows is that the peelers experts are just shooting at the wrong standard, and they don't have the evidence, summary judgment evidence, to meet their burden here simply because they did not address state action levels. So moving on to the details, Your Honor. Well, before I do that, just so everybody's oriented, can I share my screen with you?
Yes, go ahead. And whoever has the floor, you don't need to ask for permission. Just go ahead.
Okay. This map is, it's approximate, and I'm just trying to give the court a general sense of what it is that we're talking about. We're talking about the tort claims. And so we're not talking about claims that arise under the lease. And those claims, based upon your ruling on the economic loss rule, the lease controls the peeler's claims with respect to things within the lease. And so what we're talking about is the claims that are outside of either the buffer zone lease or the mining lease. And all this is intended to show you, Your Honor, is geographically where those areas are, superimposed on where the peeler's experts have identified alleged contamination. So those three red areas that you see outlined there, that's the geography that we're talking about. Okay. So then moving on to, let's talk about Taco Cabana first. Taco Cabana was a case that arose between two parties, a seller and a buyer of a property that previously contained underground storage tanks. And the buyer of the property, following the sale, found some environmental contamination on the property and sued the seller. They sued the seller under both statutory tort claims, that is a negligence per se claim, and trespass. In the trial of the case, the buyer actually won, but the trial court within the San Antonio circuit entered a judgment notwithstanding the verdict. So the judge entered a JNOV. That JNOV was upheld by the San Antonio Court of Appeals. And as I said a few minutes ago, the petition was denied by the Supreme Court. Now, let's go ahead and open up the opinion, Tony, if you would, please. So this is the opinion. And if we could just go down to the first highlighted section, if you would. And zero in over there on that first column, if you would. And so what the court addressed was, in the instant case, although the Taco Cabana halted construction due to the strong odor of hydrocarbons, that was the indication of contamination, the evidence established that the suspect soil did not contain contamination exceeding state levels. And then goes on to say in the next highlighted section, Taco Cabana was not legally harmed by the omission unless it was established that the contamination from the former tanks exceeded state action levels. So the court is essentially adopting the levels set by what would eventually become the Texas Commission on Environmental Quality as the threshold for a tort injury under these circumstances. Now, this is the discussion where they're talking about the negligence per se. And I think that this next section is important to this case because the court goes on to describe Taco Cabana argues, however, that the record contains evidence from which the jury could reasonably conclude that the contamination exceeded the state action levels, which would have triggered the duty to report and potentially the duty to remove. It points to the evidence regarding the strong odor of hydrocarbons, the fact that levels were close to the state action level, the expert opinion testimony suggesting that it was possible that the level of the contamination exceeded state action levels. The court said, we are not persuaded by this argument. In other words, they held the line that this is an objective standard, that there needs to be evidence that the action level has been exceeded. Nothing less than that meets their burden under the Texas rule. And if we go on to the trespass section, let's just skip down to the trespass section. The court contains, the opinion contains similar language that to the extent that any common law duties regarding removal of contamination existed, such duties have been displaced by the water code and implementing administrative regulations because the legislature has, and let's skip over. delegated to the TWC the task of determining the appropriate cleanup standards. The statutes in place dictate when corrective action is necessary. Thus, unreasonable levels of contaminants on the land would be levels which exceeded state action levels. Because the evidence presented at trial did not establish Exxon failed to remove soil that contained contaminants above state action levels, Taco Cabana failed to establish its trespass theory of liability. So both under a statutory tort and under a common law tort, the San Antonio Court of Appeals applied the objective standards set out by the state of Texas by their environmental rules. So that's Taco Cabana, Your Honor, and I'd just like to touch on and reemphasize that there's no language that we looked at, and there's no language that appears elsewhere in the opinion that limits this opinion to underground storage tanks. There's clear language that we discussed that it's an objective standard where possibly and may and suggestive evidence is not good enough. You need objective evidence of actual samples exceeding a numerical state action level. And as we'll show, the appealers just haven't done that. The next case was by the El Paso Court of Appeals. And Tony, if we could just pull that up very quickly. It's ZAO v. Yarborough. The site is 50 Southwest 3rd, 531. And if we just jump to the highlighted section there, down there at the bottom in the second column, the court determined, citing Taco Cabana, the El Paso Court of Appeals states the court determined that because the state of Texas determined the level of contaminants to be not unreasonable, a private cause of action for trespass could not be maintained. We agree with the sound reasoning of the San Antonio Court of Appeals. So here's another opinion endorsing the same objective standard. The next case that we want to talk about is the Abundis v. Explorer pipeline case. This is a federal case. It came out of the Northern District of Dallas. The citation is 2003 Westlaw 22976614. And why don't you just go ahead and pull that one up too, Tony? There you go. You already got it. One of the things that's important for this case, in some of the ways that the appealers have tried to distinguish Taco Cabana, is this particular case doesn't involve underground storage tanks, Your Honor. If you look at that first highlighted section, it makes clear that what was at issue in this case was a spill from a pipeline. The defendant didn't even own the pipeline. They owned the product within the pipeline. And the allegation is that those refined oil products impacted third-party property, that is the property of the plaintiffs. And so this was not a UST case. And the federal court in the Northern District of Texas still applied the standard from Taco Cabana, the standard from Yarborough, that there had to be an exceedance of a state action level. So if you just jump, I think, down to the next highlighted section, we'll just quickly look at.
And what case was that?
This is the Abundis v. Explorer pipeline case, Your Honor.
Thank you.
So just scroll down there, Tony. You see that there's a citation to both Taco Cabana, and I think there may be one to Yarborough as well. And the federal court's simply stating there that the plaintiff's trespass, and I think they also had allegations of nuisance, are barred because they didn't show an exceedance of a state action level. So then the next cases that I want to talk about are cases that actually we're coming back to the San Antonio Court of Appeals, and we're looking at the Easy Mart Stores cases. I've only put up the most recent one because they're somewhat repetitive. The appealers argue that the Easy Mart Stores cases actually narrow the rule in Taco Cabana, but I think I will be able to show you by looking at the case language itself that is indeed not true. This is a case that's 12 years after Taco Cabana. And again, the San Antonio Court of Appeals is stating the same rule. So let's just jump to page 8, to the first highlighted section, Tony. Go down there. And so the San Antonio Court of Appeals in Easy Mart is stating the rule from Taco Cabana. This court has held that because administrative regulations dictate the appropriate cleanup standards, unreasonable levels of contaminants on the land would be levels which exceed state action levels. That's the rule from Taco Cabana, Your Honor. And then let's look at that next thing. And there's a citation to Taco Cabana. If the contaminant is harmful to human health and safety or the environment, it rises to the state action level. And they cite the Texas Administrative Code in Chapter 334. And this is the part that the appealers point to as saying that it narrows the holding, but it actually doesn't. The court goes on to say, in Roland Hall's A+ transmission, we held that the Hollands were not required to show actionable levels of contaminant on the Easy Mart site to recover damages to their own property. So what they're talking about here, Judge, is the Easy Mart site is the site where the tanks originally resided. And so that part of the property had been remediated, but they go on to say, as long as there's evidence of contamination in excess of state action levels on their land, and their land was adjacent to the land that contained the underground storage tanks. And so in essence, there's a couple of things here that are critical to our discussion in this case. And that is, one, they're making very clear that the state action level requirement still applies, even if you're talking about property that is separate property that's been adversely impacted by the movement of contamination that originates somewhere else. That is, the Hollands property is not where the tank leaked, it's where the leakage moved to. And then secondarily is that you still need to show exceedance of a state action level on that property. And so that's one of the key things that I think the appealers have been arguing about is that, well, because this is Peeler Ranch land separate from the leases, that this standard no longer applies. Well, what Easy Mart says is that indeed is not the case. You still have to meet the state action level requirement. And then the other thing that's interesting, and I think worth pointing out about this opinion, is one of the Peeler's public policy arguments is that, a rule like this would simply abrogate the ability of property owners to assert torts from environmental contamination. Well, that's clearly not the case, because the Easy Mart plaintiff, that is the plaintiff who had contamination on their property from the adjacent storage tanks, they were actually successful at showing that their property contained contamination above state action levels. And so it's not an abrogation of the tort. The tort still exists. It's just the setting of an objective standard that sets forth when a party can actually recover. Just note for one other thing, that the plaintiffs in the Easy Mart cases asserted causes of action for trespass, negligence, and nuisance, all of which arose from alleged contamination to real property. The next case I want to talk about is the Houston Unlimited Metal Processing v. Mel Acres case. This is a case, it's really a case, I think you may have heard something about this case already, Judge. It's a case that deals primarily with stigma. Yeah. But there is some suggestion by the plaintiffs that somehow or another this case limits the ability or restricts the application of the state action level requirement, and that is simply not the case. If you jump to page 7 in the first highlighted section, again, there's a long discussion of the Taco Cabana case. The court goes on to say in summary, however, the court concluded that any common law duties to remove the contamination have been displaced by the applicable administrative regulations because the legislature had delegated to the commission the task of determining appropriate cleanup levels. because the applicable cleanup level regulations dictate when corrective action is necessary. Unreasonable levels of contaminants are those that exceed the state action levels. That's the ruling from Taco Cabana, Your Honor. And that's the ruling that they applied here. The question that the court was addressing was there was evidence that those state action levels had been exceeded at one point in time, but they no longer exceeded. And so under those circumstances where they had met the objective standard, but they no longer, as of the date of trial, met that standard, was there a claim for stigma damages from that temporary exceedance of those objective standards? The case never questions the objective standards set out by Taco Cabana. All it does is say, well, if it's there only temporarily and then it's removed, can you get stigma damages for that temporary condition? And as a opinion based upon stigma damages, this opinion from the Houston Court of Appeals is not persuasive authority because, of course, the stigma damages ruling by this court in this opinion was actually overruled by the Texas Supreme Court. But I mean, for purposes of today, the important thing is even this opinion fully endorses the objective standards set out in Taco Cabana. And this is another case where it's not a UST. The discharges came from a metal processing facility and moved over land in a drainage ditch. And it's another case where they're addressing whether or not state action levels were exceeded in a third party's property. So it wasn't the metal processing facility they were talking about. It was kind of the down gradient properties that were impacted by the discharges. The peelers also in their response cite to Stevenson v. EI DuPont. I'm not going to bring that opinion up, but Judge, that case is just not applicable to what we're talking about here. For one thing, it's an air emissions case. It's not, impacts to soil and groundwater like what we're talking about here, not what was addressed in Taco Cabana. DuPont in that case was a defendant, and they were arguing about a concept of whether or not the air emissions met a standard of substantial damage. There was some discussion about the Taco Cabana case and the use of state action levels, but the court never engaged on whether or not state action levels were an appropriate objective standard. It's an opinion by the Fifth Circuit. And, just as sort of logistically, the San Antonio Court of Appeals reaffirming the objective standard set out in Taco Cabana in the Easy Mark case happened 8 years after Stevenson. So if Stevenson somehow overruled Taco Cabana, certainly they would have addressed it there. So the last case that I want to talk about is the Forest Oil case, another case that the peelers are suggesting abrogates the objective standard set out in Taco Cabana. And this is just a misapplication of this case, Your Honor. Forest Oil was a case that dealt with whether or not the Texas Railroad Commission had so occupied the field of environmental protection that it had abrogated or completely eviscerated common law tort claims for environmental contamination. And the Supreme Court said, no, that's not the case. Private parties can still bring causes of action for, trespass and nuisance and the like for contamination to real property. But that's not what we're talking about here. Forest Oil is about, there's no tort action, and Taco Cabana and the progeny that we're talking about it recognizes that causes of action. It just sets an objective standard for when there's been a legal injury. And so Forest Oil is just not relevant. It doesn't address, there's no discussion in the opinion at all about state action levels. None of Taco Cabana is not cited in the case, and none of the cases that we just went through were cited in that opinion, and for good reason, because they are not relevant to the complete abrogation of a tort, because they're simply addressing what the objective standard of the legal injury is, which is a distinct and different thing. You know, the other thing that's worth thinking about is by the time Forest Oil was decided in 2017, Taco Cabana was 18 years old. It had been the law of Texas for 18 years. It had been implemented by the 4 or 5 cases that we've already talked about. And certainly if Forest Oil intended to overrule the San Antonio Court of Appeals opinion on Taco Cabana, they would have mentioned it in the opinion. And so the bottom line is that case is just not on point. So in summary, on the first issue that we're talking about here today, that is the legal issue, does the state of Texas establish an objective standard for these tort claims? Taco Cabana is still good law. It hasn't been overruled or even distinguished in any significant way over the last 20 years. And it dictates that the appealer's burden is to prove an exceedance of a state action level to prove a tort injury arising from alleged environmental contamination to real property. So that's the first issue. Now I want to talk, well, let me briefly, before I get there, let me just go through the appealer's public policy arguments as to why Taco Cabana should not be the law. First, they say it's revolutionary. That hyperbole is, I think, misplaced here. If there was a revolution, Judge, it happened 20 years ago. No other states follow this rule. That's simply not true. We've cited several of those in our reply pleading, Your Honor. They ignore the policy considerations for why this is a good rule. For one thing, the state agencies that set these state action levels, they're the experts in the field. You know, trial judges and juries are not. It avoids inconsistent standards. It sets a uniform standard across all regulated and entities within the state of Texas. It creates procedures for one of the thorniest issues that we have in this case, and that is distinguishing what's naturally occurring versus what's contamination. That's a complicated scientific issue. These state standards help you work through that, particularly on the ecological side. And then finally, as the court has noted previously and in other hearings where this issue has come up, it makes common sense to have an objective standard so that people know what it is that they're trying to meet. And then briefly on the limitations issue, I mean, the appealers make this argument that somehow there is, it creates a limitations trap, if you will, because they have to file their lawsuit before they know that they have an exceedance of state action levels to avoid, having trouble with the statute of limitations, and that creates an equitable problem in terms of filing the lawsuit. That's an illusory problem because it just comes from the fact that we have this disagreement about when the injury accrues. I mean, obviously the statute of limitations doesn't start to run until the injury accrues. And so if the injury doesn't accrue until you go over the state action limit, then that's when the limitations period starts. Now, the parties, the movements have filed motions for summary judgment on statute of limitations based upon the way that the appealers have articulated their claims. And, that's what good lawyers do. They're protecting against the possibility that the injury, that there is, some sort of cause of action that accrues back then. But if we're correct, and that is the statute of limitation, that the accrual of the injury occurs when the when you exceed the state action level, that whole thing goes away. And this whole idea that, that there's this conflict between the law on this point is just not right. We just need to know what that accrual date is. That's all.
And let me ask just, So you're saying that the state action levels are found just in the administrative code dealing with underground water tanks, underground fuel tanks, or is there another part of the administrative code or water code where the state action levels are found?
Yeah, there is. And that's what I'm about to get into now. So the first part that I've just gone through is sort of like, you know, as a legal matter, they've got to show an exceedance of a state action level. This next part, what I would like to do is just go through and show you where the state action levels are, the fact that the peeler's definition of contamination does not fit those state action levels, and you know, just illustrate that second piece for you. And then that leads us into sort of demonstrating that their expert evidence doesn't meet their burden. But the short answer to the question is that the state action levels at issue here are found in the administrative code for the Texas Risk Reduction Program, which for the court reporter's benefit, I'm going to call TRP. It's an acronym, it's TRRP, but that's where it is. To give you a site, it's 30 Tex admin. I think the ecological one is 357, but you know, it's in the 350s.
Okay.
So on this sort of the evidence piece of this, there's kind of two main points, Judge. First is the state of Texas has in place state action levels that are applicable to the Peeler Ranch and the dispute that we're at issue here. So that's the first piece, what you were just asking about. And the second piece is that the state of Texas has also explicitly rejected the exceedance of background as a general matter as a basis for determining contamination, which is what the plaintiff's experts, particularly their expert Anthony Brown, has done. So let's start our discussion of this by looking at some of Mr. Brown's testimony. And so, Tony, if you could just pull up his depo sites for me, please. No, that his Anthony Brown's deposition sites, please. Okay, so this was a deposition of Anthony Brown, which I took on May 20th in this case, Your Honor. And I'm just going to go through a few of these sites where I tried to get him to tell me what was the basis for his determinations of what contamination was and how he defined contamination. So my question, and again, you're making the point here that based upon the tasks that you are given and your definition of contamination, these regulatory standards are irrelevant to that assessment. Is that right? That with respect to the work that we have performed here, that's correct. So Mr. Brown in that testimony is acknowledging that he's not, as part of his definition of contamination, looking at state action levels. He's affirmatively saying that he did not do that. And then I went on a little later in the deposition, and your definition of contamination, what you're measuring the laboratory results against, is what you determined or what you had others determine for you is a reasonable upper bound of what the top of the background range is on the Peeler Ranch, right? And Mr. Brown responded, yes, I think that's a reasonable summary. So what he's saying in that deposition testimony, Your Honor, is he was basing contamination based upon exceedances of background. All right, let's go on to the next one. And then following up, a similar question, Judge, in looking at your figure 47, which is the main figure where they describe the areas of contamination and the various sample locations where you're indicating an exceedance of background levels, do you know if any of the concentrations measured at those locations exceed any applicable regulatory standard? Mr. Brown testified under oath. As I sit here, I do not. We did not evaluate the concentrations relative to regulatory standard. We simply evaluated them relative to the natural background concentrations. Again, Judge, that's the wrong test. That's the wrong test. All right, let's go on to the next one. So I asked Mr. Brown, all right, and so to go back to my prior question, just to make certain my record is clear, with the exception of the comparison of the SAR for electrical conductivity to the Alberta Canadian standards, which obviously are not Texas state action levels. You are not going to offer an opinion with respect to any of these laboratory concentrations as to whether or not they exceed a regulatory standard, correct? That is not an evaluation we have performed to date. We simply evaluate the concentrations relative to the background, that is the baseline concentrations naturally present. Is that the last one, Tony, or do we have another one? That's it. So, you know, I show you all that, Judge, just to make the point that the expert evidence that the appealers have put forward is based on background, and their expert that goes to these issues affirmatively told me multiple times during his deposition that he was not measuring contamination or alleged contamination against any kind of regulatory standard as is required by Taco Cabana. All right, so let's talk about the rules that that set the state action levels that are applicable to the Peeler Ranch. And I also mentioned that those are the TERP rules. So let's first go. These rules were promulgated by the state of Texas back just before 2000. I think the final promulgation was in 1999. And let's look at the preamble to that rule so that we can just get a sense of what the Texas Commission was trying to do. So they were effective September 23rd, 1999. Let's zero in on that highlighted section there, Tony. And so this is the Texas, what is now the TCEQ, describing the purpose and intent of these rules. As part of the Commission's regulatory reform goals, the Commission is adopting new rules to establish requirements for corrective action at sites where a release of a chemical of concern has impacted the environment. And then it goes on to describe these as the TERP rules. And then in the second paragraph, first sentence, the adopted rules outline a comprehensive program that addresses the investigation of contaminated sites, establishes reasonable standards for notice, provides flexibility in calculating site-specific cleanup levels, and sets forth appropriate response actions to address environmental contamination. That's what we're addressing at the Peeler Ranch. And if we go down to the next paragraph, it's not highlighted, but if you just look there, you see that what the TCEQ is doing is, you know, all of these regulatory programs where it's important for them to develop cleanup levels, the state Superfund program, the voluntary cleanup program, the petroleum storage tank program, which is sort of the next generation after the UST program, the industrial and hazardous waste program, the underground injection control program, all of those utilize these TERP standards that are applicable to the Peeler Ranch. And it's these cleanup standards kind of exist as a separate standalone regulation, Your Honor, that are intended to fill in the gaps, to make certain that regardless of what regulatory program is applicable, that the state of Texas has cleanup standards that apply that protect human health and the environment. We have some testimony that we cite in our brief by Mark Hemingway, who, we talked about him a couple of weeks ago, Your Honor, has over 35 years of experience in the state of Texas doing this kind of work, where he said these TERP standards are the applicable standards. The Peelers have no contrary evidence. They don't have an expert talking about whether TERP is or isn't applicable under these circumstances. All right, the next point I want to make, also based upon this preamble, if Tony, if you could jump to, I guess it's the highlighted section. This is we jumped quite a few pages in the preamble, Your Honor, but we only attached excerpts to the motion because we figured you didn't want the whole thing. But one of the things that was raised by commenters. You know, when rules go through regulatory proposal and comment, one of the things that can happen is people in the community can provide comments. And one of the comments was, well, what about the potential that contamination can just be above background levels? Isn't that potentially a problem? And that question was raised in this comment right here that we see on page 137 of the preamble. If we go on to the next page, Tony, if you could just go to the next page and look at the next highlighted section. The Texas regulatory agency specifically said, we're not promulgating state action levels based upon exceedances of background. The agency said the TURP rule being promulgated today completes the agency's move away from background-based to risk-based process for determining cleanup levels. And their regulatory speak for cleanup levels is PCLs, which stands for protective concentration levels. The commission finds by adopting the TURP rule that there are protective risk-based concentrations of COCs which can remain within an environmental medium considering all relevant human health and environmental exposure pathways that are so low as to be below levels of regulatory concern. And then this next sentence I'd like to emphasize, it is not defensible from a scientific perspective to refer to such as an environmental medium as contaminated. So just, you know, TCEQ has determined that these bumps above background by and of themselves, that is not, from a scientific perspective, it's not defensible to call that contaminated. Now, there is an exception, and it's an exception that makes sense, and that's the one that's addressed down here in this bottom sentence, where it states, under TURP, background normally only becomes an issue when a concentration is greater than the risk-based PCL, in which case the background value becomes the PCL. And if you think about it, Judge, that makes sense, because if you calculate a risk-based level of, say, 10, but the naturally occurring concentration is 20, you can never get to 10 because what's naturally there is 20. And so it's under those circumstances, and it happens a few times with compounds that, you know, you do these risk calculations based upon cancer. I mean, a common one is arsenic. You know, if you do the standard risk calculation on arsenic, you come up with really low numbers, but arsenic naturally occurs in all soils, and some soils in Texas, you know, the naturally occurring concentration of arsenic is 15 or 20 parts per million. And you can't regulate below what's naturally occurring. And so that's what this exception is. Now, under TURP, and it's suggested up here in this paragraph up here, you actually regulate human health and environmental exposure pathways separately. So there are separate PCLs or state action levels based upon human health versus environmental ecology type issues. I think what we're primarily concerned with in this case is the ecological issues and the ecological issues associated with returning the Peeler Ranch to its productive use as a cattle ranch. But we'll talk about both. And so if we look just quickly, if we look at the human health issue, the TCEQ has established, it's created a table of PCLs based upon human health that's available through the regulations. And if Tony, we just pop that up real fast, we'll show that to the judge. It's just, you know, it's a long table with chemicals on the left side and relevant concentrations based upon whether it's present in soil or whether it's present in groundwater and the like. And this table, there are a number of, particularly the metals that are called out by the plaintiff's experts in this case on the human health table. And there's testimony from Mark Hemingway, which we cited in our brief, that there are no exceedances of these human health-based PCLs related to environmental releases on the on the property that we're talking about, that is outside of the leased buffer zone lease and the mining lease, the ones that are relevant from a tort standpoint. The peelers have no contrary testimony. So the TCEQ has also published procedures on how to go about creating the PCLs for ecological harm, Judge. It's a little bit more complicated than a table. And so if we go to the TERP process, this right here is, here's your citation to where it is in the administrative code, Your Honor. It begins at
I had found it. Go ahead.
So this is the rule, and if you jump to page 96 on the PDF, Tony, there you go. And so this is the regulatory construct by the TCEQ on how they go about developing ecological protective concentration levels, or PCLs. And again, that's the state action level designed to protect, the environment, separate from human health. And if you look at that, it says the purpose of ecological risk assessment will be to characterize the ecological setting of the affected property, identify complete or reasonably anticipated to be completed exposure pathways and representative ecological receptors, scientifically eliminate COCs that pose no unacceptable risk, and develop PCLs for selected ecological receptors where warranted. Now, because many of those factors are site-specific, ecological PCLs tend to be PCLs that are developed for a particular site. Like, for example, you have different ecological receptors. You may have alligators as an ecological receptor in Galveston Bay, but you're not going to have them in El Paso or some other place in West Texas. And so the way that those PCLs are developed are based upon, the site where you are going to, implement that particular state action level. All right, so let's talk about how you go about doing that. And the TCEQ has a guidance document on how to go about doing this process. And so if you look at, let's jump to the guidance section, the risk assessment guidance, and let's go to section 6.62. It's at PDF 63, I think. So one of the ecological receptors that the state of Texas looks at, if it's relevant for the particular site, is livestock. So the state of Texas has, in their guidance, has stated potential risk to livestock receptors such as cattle, horses, goats, and sheep should be evaluated where livestock are known to be expected to use a site. Although uptake of COCs by livestock may result in risk to humans, that long acronym has to do with ecological risk assessments, should evaluate the potential health risk to livestock animals themselves because of exposure to site COCs. So the process that the TCEQ has set out includes the ability to address ecological receptors like cattle. And so the process has that ability. One of the complaints that the peelers raise in their response to our motion is that this TERP process doesn't address the potential for bioaccumulation. And they argue that some of the metals that they are concerned about in the sampling are bioaccumulative. Well, that's simply not true, Your Honor. The The rule actually does specifically address bioaccumulation. So Tony's got the rule up there, right there. And site specific, the highlighted section states site specific studies which may be conducted include, but are not limited to, development of site specific bioaccumulation factors through the collection and analysis of tissue samples from appropriate ecological receptors. So the process does include the ability to address bioaccumulation. Let's just jump quickly to the guidance.
And would the landowner or the peelers in this case have the ability under the risk assessment program to have one of these tests done to see if there is a danger of bioaccumulation?
Sure. I mean, it may require the gathering of some data. And it would have to be done by somebody other than one of their retained experts. But our expert, Tim Verslaika, who you heard about, perhaps a month ago, that this is what they do. Now, I mean, Mr. Peeler couldn't do it, but, they've hired a number of experts to go out and do their environmental site investigations across the property. They certainly could have hired an ecological toxicologist that could have developed the information that was necessary in order to generate protective concentration limits based upon bioaccumulation. And the procedures for how to do that are set out in this manual. And the TCEQ has put in an enormous amount of effort putting this manual together. They didn't do it for no reason, Judge. They did it because they felt like this was an important part of protecting the environment and creating procedures so that the regulated community knows how to go about developing these risk-based state action levels that the state has determined is the proper way to evaluate environmental contamination. So I won't linger on this, but there is an entire section to this guidance manual that describes how to go about addressing bioaccumulative compounds of concern. The next thing that the peelers argue is that the that the TERP process doesn't regulate salt. Well, that's also not true, Your Honor. The human health side of the regulatory process doesn't regulate salt. But what we're primarily concerned about here, and as the peelers seem to agree, is impacts to the environment. That is, impacts to the property's ability to support cows as a cattle ranch. And if you look, this is another guidance document from the TCEQ on the TERP process. It states in the first sentences that salts are not, or these compounds, which include a bunch of salts, are not regulated from a human health standpoint. However, under TERP, ecological criteria would still apply. The CO2 concentration should not be high enough to make a natural resource unfit for use. And then if you scroll through this table, I've just highlighted for you the compounds that appear in the various environmental site assessment documents that the peelers point to, including calcium, chloride, sodium, sulfate. So I don't know if they have sulfide, but they certainly have sulfates. And let's go to the last page there, Tony. Oh, that's it. Okay. Yeah. And so, the guidance from the agency specifically says that, the impacts of salt is something that should be addressed as part of the ecological assessment necessary to generate the protective concentration limit or the state action level. There's deposition testimony, as a matter of fact, by our expert, Mark Hemingway, where he explicitly says that TCEQ has a process for creating a PCL based upon chlorides. He's familiar with it. That same thing is true for the other salts that we just looked at. The peelers do not have any contrary expert testimony on that point. The peelers finally suggest that without support, I will add, that the requirement to do this kind of development process of coming up with a PCL somehow makes the applicable cleanup level different from the state action levels that were addressed in Taco Cabana. That is almost like, well, it has to be a state action level that appears on a table. Well, that's not, that concept is not supported by the language in Taco Cabana. If we go back to the Taco Cabana opinion, what the court said was, to the extent that any common law duties regarding removal of contamination existed, such duties have been displaced by the environmental statutes and implementing administrative regulations because the legislature has delegated to the agency the task of determining appropriate cleanup levels. And the key here is, what level or concentration do the statutes and the implementing regulations dictate corrective action is necessary? And so this process that we've gone through, while it requires some work to create the PCLs, clearly fits within this overall direction from the San Antonio Court of Appeals to look to, how does the state agency dictate when corrective action is necessary? And whether or not that dictation of a cleanup level is set out in a table, or whether or not that cleanup level requires some sampling and some work by an environmental toxicologist, doesn't change the fact that the state has set out what that cleanup level must be. And we would submit, Your Honor, that it is because the proof of a breach of duty in this case, and that is the exceedance of the state action level, falls to the peelers. It's their burden to come up with that number. It's their burden to do that work, to develop that PCL. And, you know, just to put this in perspective, we're not talking about an affirmative defense here, Your Honor. I mean, this is not something that San Miguel or STEC or KMG needs to prove as part of some kind of affirmative defense. We're talking about the peeler's primary burden of proof to prove their tort claims. They have to prove a breach of duty. The San Antonio Court of Appeals says that that breach of duty does not incur until there's an actual injury measured by the state action level exceedance. And whatever it takes to make that demonstration, that's the plaintiff's burden. And as we looked at, going back to Mr. Brown's testimony that we looked at just a few minutes ago, they not only did not do that, they purposefully avoided doing that. Mr. Brown testified, I didn't even try. And that's simply not good enough from a summary judgment evidence standpoint. And so just to wrap up here, Your Honor, San Miguel and STEC and KMG asked the court to grant its partial motion for summary judgment. First, they asked that the court affirm that the threshold for environmental contamination-based injury in tort is the exceedance of a state action level. And second, we asked that the court rule that the peeler summary judgment evidence is not sufficient to meet that burden. That's all I have, unless you have questions.
And exactly your position is on COCs, or maybe they're not COCs, on elements such as sodium or sulfur, sulfates, for which there is no state action level. Your position is that there has to be a study done that shows that the particular level in some place has some injurious effect.
That's not exactly right, Your Honor. Our position is that there is a exact level for those compounds, that is chloride or calcium. I can't tell you what that level is because there's a process that needs to be done first that is prescribed by the state that leads you to what that number is, and a site-specific number for the peeler range. And that's a state action level as much as a number that appears on a table. So I don't think it's correct to say that there is not a level, because there is a prescribed process by the state of Texas that leads to a level that's site specific for the peeler range.
have someone post to everyone in the meeting the slides that you put up today?
Sure. Yeah, absolutely.
Thank you. All right. Mr. Schneider, or did you?
Your Honor, Mark Guthrie for
All right.
Kiewit Mining Group. Good. I guess it's afternoon now. Kiewit Mining Group adopts Mr. Sutherland's argument. I want to add a few things. Then I want to talk about the objection to certain summary judgment evidence that the peelers have submitted. But you asked a question that is important, I think, in Mr. Sutherland's presentation. That was, do the peelers have the ability to conduct this testing to derive a protected concentration limit? And the answer to that's clearly yes. The last number I've seen from the peelers indicates that they've spent over $1,500,000 on their experts in this case, most of it on the environmental experts. They certainly had the ability to go out and hire an environmental toxicologist to determine what the state action level was for salt on one or more locations on the Peeler Ranch. And the expense here is really not relevant. It's just a matter of hiring another expert. Next, and if I can share my screen, I know you told us not to ask permission, but it's ingrained in me.
Go ahead.
Bear with me just a second. Where did the button go? There we go. I'm sorry. All right, can you see that now?
Yes, sir.
Texas is in line with other jurisdictions, state action levels. Mr. Sutherland referenced that other cases across the country held similarly to Taco Cabana, and I just wanted to provide you with some cites to those cases. These are in our briefing as well, but there are cases from South Dakota, North Carolina, Kansas on similar issues. And we believe that the policy that underlies this state action level scheme includes that state regulatory authorities are better situated to determine what is contamination and what is not. And we're all better off having a more objective definition of contamination rather than a subjective one, such as you discharged something on my property or into my groundwater, even though I don't use the groundwater and the groundwater is very salty. It's contaminated and I'm entitled to recover money based on that. Following Taco Cabana's precedent would not unfairly prejudice the peelers or any other landowners. It's already the law. The regulatory schemes and state action levels provide a uniform system instead of something arbitrarily determined after the fact for litigation purposes alone. And as Mr. Sutherland addressed, the landowner would not be at an additional risk of the statute of limitations running because the clock starts when there is an injury, when there is harm. If the law was what the peelers want it to be, a private plaintiff could sue another claiming contamination where there's only a de minimis amount of potential contaminant over a pre-existing level, that is the background level, where that excess amount causes no real damage to human health or other relevant environmental ecological receptors and no interference with the use of the property by the plaintiff, publicize that lawsuit, publicly claim that their land was contaminated, and assuming that you can recover stigma damages in Texas after remediating a de minimis amount of a substance of concern, seek stigma damages. And here's a real world example. Somebody could sue their neighbor and claim contamination, damages for contamination, where a neighbor applies Roundup to their fence line to prevent weeds from growing up into the fence, and where the wind blows and that Roundup drifts over to the plaintiff's side of the property, where it does no real damage to the property other than killing grass on the plaintiff's side of the fence, which you can fix by digging up an inch or two of soil and replacing that soil and replacing the grass. But after spending a small amount of money to do that, your neighbor could sue for stigma damages for the reduction in the value of their property, many times the cost of the remediation. And that rule would cause the ultimate damages amount to depend on the total value of the real estate involved. If you just take a house and you claim, or somebody claims that that house sits on contaminated land, it may make it harder to sell it. And you may have to accept a 10 or 20% reduction in the selling price after a claim of contamination has been made. But if you live in a $50,000 house, or you're talking about a $50,000 house, you're talking about $5,000 worth of stigma. If you live in $1 million house, you're talking about $100,000 worth of stigma. That's the problem with not having some kind of an objective standard. And contrary to the peeler's point,
to go back to my example about an automobile where there's an automobile collision, and yes, it's repaired, but that the fact that the automobile has been in a collision will be typically held against the owner whenever they go to sell it or trade it in. Isn't that just a matter of you find your victim the way you find them? And if you hit a Chevy Impala like mine, it probably I got hit about 1.5 years ago, and I didn't even bother because my car was old enough to ask for stigma damages. But if I had $1 million Bugatti and you hit it, even after it was painted, I'd probably be wanting some stigma damages.
Well, I don't disagree with that, but that presupposes that you had an accident.
Well, sure. No, I mean, they have to
right?
be proof, but
just like it presupposes that there is really contamination. You know, I'm not arguing with you about stigma damages here in this motion anyway.
Okay.
But the point is, there has to be an accident in your example, and contamination in this case in order to even talk about stigma damages. Real contamination that is objectively defined based on the exceedance of a state action level. So the peelers also claim that they would be without a remedy if the state action level requirement really exists. And just go back to my example, please, of the roundup on the fence line. There are alternatives to suing the neighbor for contamination. You can sue for property damage because your grass doesn't grow, and you can sue for the cost to take out the soil and buy new grass and have that new grass put in on other theories because of that drifting of the Roundup. If it interferes with your use of the property, whatever it is, whatever the problem is, you could sue for nuisance. Actually, as the Supreme Court said, and I think it was the Crosstex case, nuisance isn't a cause of action, but there are different causes of action like negligence that you can assert in order to recover for a nuisance. The peelers have made very clear, the peelers have made very clear here that they don't sue for nuisance and that their pleadings don't state a claim for nuisance. They've said it on the record. But you could, if it interferes with your use. You could also, to protect yourself, enter into contracts requiring repair of adjoining property or third-party property that is damaged as a result of whatever operation you're talking about. In a construction project setting, that happens all the time, where you get the contractor to agree to repair damage to other property that they caused while doing the work on the owner's property. And you can also require indemnities for damage to adjoining property. You can also, if you can show irreparable injury, get an injunction and restrain what you consider to be ongoing harm. That's also a possible remedy. So you don't have to wait until a state action level requirement is met in order to deal with a concern that your property is being harmed. But if you want to sue for contamination, I think the law is pretty clear that you do need to show a violation of a state action level in order to maintain that claim. And that's based on both a duty, as Mr. Sutherland pointed out, to clean up an unreasonable level of contamination. And it's also based on the ability to recover damages. In their briefing, the peelers also say that federal statutes like CERCLA don't have limitations periods. And I wanted to point out to you that that is not true. CERCLA has a 3-year statute of limitations period. The movements believe here that there's no evidence that the peelers have presented that would preclude a motion for summary judgment, and the motion should be granted that the peelers take nothing by reason of their tort and statutory tort claims, because they have no evidence of a state action level violation. I think you will see in the peelers' response that they admit they have no evidence of an exceedance of a state action level or a protective concentration limit. Now I'd like to get to the objection and motion to strike evidence that the peelers have offered in support of their response to the motion for summary judgment. I am only going to hit the highlights on that because I don't think the evidence is relevant to the motion, because I don't think these experts, Brown and Johnson, base any contamination conclusions on the violation of a state action level. In fact, one in the declaration that we're complaining about makes pretty clear that he's talking about only an exceedance of background. The peelers have offered, but not attached to their briefing, a declaration from one of their experts, Gordon Johnson, and a declaration of their other expert, Anthony Brown, which they had previously listed as exhibits 9 and 10 to their response to Steck's motion for summary judgment on tort claims. Those were filed on September the 22nd of this year. And those were the first time we've seen them. They were filed months and months after depositions and after the applicable expert deadlines that we'll look at. And these declarations contain new and previously undisclosed opinions. They also contain a bunch of conclusions. And in the case of the Brown affidavit, they attribute actions to my client, Kiewit Mining Group, based on a citation to a deposition of its corporate representative that does not say what they say it says. And this fact that they assert as a positive assertion is just simply not true. Now, again, I don't believe that these declarations are relevant to any issue in this state action level motion for summary judgment on tort claims. But my concern is if we allow this without objection here, the peelers could argue later in connection with a future motion that these declarations are admissible because they are already in the court's record. Allowing this late evidence would prejudice KMG, San Miguel, and Steck, and we object and move to strike the declarations and ask the court not to consider them as summary judgment evidence. And as I'll get to, in addition to just being late, horribly late, other grounds exist to exclude these affidavits. Here are the applicable deadlines. January 31, 2020. And these deadlines come from an agreed scheduling order. It's not a unilateral court order. It also represents the parties' agreement, which I think is significant. There was a January 31 deadline to designate experts and produce expert reports on issues on which a party had the burden of proof. March 13, 2020, designate rebuttal experts and provide rebuttal reports. Discovery closed June 12, 2020. And we had a September 15 deadline to file motions to disqualify and exclude experts. The peelers produced Johnson and Brown's initial reports on or about January 31, 2020, and their rebuttal reports on or about March 13, 2020, the deadlines. We took Brown's deposition May 20th. We took Johnson's deposition May 28th. The declarations that are at issue, Brown's is dated July 14th, 2020. Johnson's is purportedly dated May 12th, 2020, and I'll show you what I'm talking about there, before his deposition, but it was not executed until he did it before a notary on June 12th, 2020, which was after his deposition. Here's Brown's signature page with the date. Here's Johnson's. I'm sorry for the quality. See, it says executed this 12th day of May 2020, but the notary jurat says June 12th, 2020, a month later. We didn't get these declarations, as I said, until September the 22nd. I don't think they've ever been produced in terms of a document production. They were attached to a response to a different motion for summary judgment that did not involve KMG or San Miguel. The declarations were executed after the depositions of Johnson and Brown, and none of the parties have had an opportunity to cross-examine Johnson and Brown on the new matters contained in them and previously undisclosed opinions contained in these declarations. The declarations clearly contain new opinions, and some are significant in terms of being opinions about causation, and the production of those after the close of discovery, after the deadlines for their reports, after their depositions were taken, after deadlines for motions to exclude experts is prejudicial to the movements. Some of Brown's new opinions, and we cite to, we attach the base form of the declarations to our motion to strike. Coal ash piled on the surface in Area A and buried in Area A and Area B has caused and is causing contamination of the Peeler Ranch. That's pretty significant to not previously have been stated. Then additional new opinions. I'm not going to read all these, but coal ash piled on the surface in Area A's contaminated soils through windblown deposition, and it goes on and on. Polluted groundwater also discharges via seeps and bed seepage into a creek. Contamination caused by the combined volume of coal ash from lignite mined at the Peeler Ranch and lignite mined from adjacent properties is greater in magnitude and extent than just the contamination caused by the coal ash associated with lignite mined at the Peeler Ranch on its own. When mining was completed in Area A on the Peeler Ranch, the entire area should have been properly reclaimed at that time. Instead, it's remained open, not fully reclaiming Area A after mining was complete in approximately 1995 has exacerbated the contamination caused to Peeler Ranch by San Miguel. Johnson has a whole lot of new opinions that he didn't put in either of his reports, any of his 3 reports. Certain areas are essentially void of vegetation and are covered by a layer of salt and other chemical precipitates that, in my opinion, are a direct result of mine water discharges. He talks about approved limits for electroconductivity of discharged water are 5 times higher than upper limits of cattle grazing plant species recommended by Texas A&M. Salts associated with allegedly contaminated mine water have killed plant species that peelers rely on for grazing cattle. There are a whole lot of them. Here's one: San Miguel intends to continue the practice of discharging contaminated mine water that is contained in ponds 7, 10, and 11 onto the peeler property. The estimated area of the Peeler Ranch that requires remediation because of contaminated mine water discharge is on the order of 500 acres. This area of contamination and plant mortality will persist for decades, if not centuries. Hence, it is essentially permanent. Unless and until these discharges stop, these areas will continue to worsen, rendering the affected portion of the peeler's property useless for cattle grazing. San Miguel cannot be relied upon to effectively remediate the areas of soil contamination. The peeler should be involved in the design, implementation, and verification of any remedial measures that are required, because San Miguel has repeatedly demonstrated a lack of understanding and/or concern, which you have to wonder about some of these as being proper expert opinions anyway. But these opinions, as I pointed out before, we don't think have anything to do with the motion for summary judgment, and here's why. The Brown Declaration, he bases contamination, or he says he bases his contamination on exceedances of over background levels. In his words, were recently established background concentrations of constituents of concern in uncontaminated soil, surface water, and groundwater for comparison with soil, surface water, and groundwater samples from areas suspected of being polluted to determine exceedances. So what he's essentially saying there is his definition of contamination is based on exceedances of background. Many of these opinions are conclusory and lack adequate foundation and are unreliable. And some of the grounds for that you will hear on the motions to exclude Johnson and Brown's opinions that were timely disclosed, that I think are set for this coming Monday. Conclusory statements cannot be competent summary judgment evidence, and we provide you a list of the conclusory statements in the motion to strike. And I'm not going to go through those, but there are many. These declarations were first provided over 100 days after discovery closed, nearly 200 days after the deadline for issuing expert rebuttal reports, about 240 days after the initial deadline for expert reports, which is where these opinions should have been included. 60 to 90 days after they were signed or executed, after their depositions, and 7 days after the deadline for the motions to exclude experts. We don't believe these are competent. The contents of these declarations are competent summary judgment evidence. And I think I've already covered most of that. Under Rule 193.6, discovery that is not timely disclosed and witnesses that are not timely identified are inadmissible unless the court finds good cause or lack of unfair surprise or prejudice. We cite a case that says that the exclusion is mandatory and automatic unless the court finds good cause or lack of unfair surprise or prejudice. And this exclusion under Rule 193.6 applies to summary judgment proceedings and to untimely expert opinions. And we cite a Supreme Court case, Fort Brown Villas versus Gillenwater, for that proposition. Not excluding these declarations, particularly where they contain new and late expert opinions, would prejudice the movements. Discovery ended a long time ago. The expert designation deadlines, report deadlines, and disclosures were required to be issued timely based on an agreement of the parties and months before the close of discovery to allow the parties adequate time to have their experts address opinions or take depositions regarding expert opinions or otherwise determine how to respond to such opinions. And if the court allows the appealers to submit these late expert opinions and the declarations that contain them, we will be deprived of the opportunity to test the appealer's evidence. We have been deprived. And even if the court were to reopen discovery now, it wouldn't remedy the unfair surprise or prejudice because we're already past the deadlines for filing the motions to exclude experts as well as dispositive motions. And we've all spent significant time and resources preparing these motions in light of the timely expert disclosures and the discovery that took place before the deadlines. This slide references the statement of Brown and his declaration that we object to. We've attached the deposition of Simon Zulu to the motion to strike. The pages that Brown cites as support, essentially what he's saying here is that Kiewit placed coal ash into a part of what was formerly water-filled in pit 10. And that is untrue. Mr. Zulu's testimony discusses building a land bridge to provide further separation between the water in in-pit 10 and the ash pile adjacent to it. And after that work was done, KMG started placing ash on the pile, not in the in-pit or not the dewatered in-pit. And so that speaks for itself, but it speaks to the reliability of this expert, Brown, in terms of making these flat factual assertions that just have no basis. So we would ask that the court strike the declarations of Anthony Brown and Gordon Johnson and not consider them for purposes of this motion for summary judgment that you're hearing today, right now. And Your Honor, unless there are questions, that's all I have. Thank you.
Not right now, thank you. Right. Ms. Whittle?
Your Honor, would you like a quick break?
Yes, let's take a break and let's call it a 10-minute break until 1:03. I'll come back then. I've had some text I need to return to.
Okay, thank you.
Thank you, Your Honor.
Actually, I do have a question, Mr. Guthrie.
Yes, Your Honor.
Are you related to Gil Guthrie?
Gil?
Yes.
Not that I know of.
Oh, okay. Gilbert, he went to Baylor. I thought that you'd gone to Baylor too. And
I did. And I sort of vaguely remember that name. I don't know why, but no, I'm not related to him.
Okay, there were 3 Wilsons in my class, and we weren't related. Thank you.
Thank you.
Sorry. Okay, you ready, Ms. Whittle? You're muted.
Oh, yes, Your Honor.
Go ahead, ma'am.
Contamination levels that regulators deem relevant for certain governmental programs do not address any material question in this lawsuit. This case concerns whether contamination violates the peeler's private rights to be free from injury to their property as defined under tort and contract law. By contrast, regulators set threshold levels for cleanup based on risk to human health, cancer, and mortality risk. The coal company's emphasis on statewide screening values amounts to a proposal that a polluter is categorically free of liability to a private landowner for any harm that falls short of regulatory thresholds. This rule would redefine tort law, including adding an entirely new material element of the law of trespass and negligence. The court should deny this motion based on the evidentiary record, which creates more than a scintilla of evidence and the applicable law. First, it is simply not the law that every property damage case requires the plaintiff to prove the exceedance of a state action level. On the contrary, the Texas Supreme Court in Forest Oil clearly has held that while regulations and orders by a state regulator certainly inform the extent to which remediation of contamination is required by law, they do not supplant the defendant's common law duties, which are also required by law. The court in Forest Oil clearly held that common law claims for contamination are not dependent on standards for regulatory compliance. Moreover, the coal companies failed to identify what regulatory state action level is applicable to this case, in which the peelers allegedly have failed to demonstrate. Second, the coal companies ignore that the peelers' negligence per se and Section 85.321 claims are also based on the coal companies' violations of regulations and statutes, which have nothing to do with state action levels. These violations are based on other misconduct by the companies, such as violation of statewide Rule 8, allowing water to come into contact with toxic forming spoil, failing to complete reclamation as contemporaneously as practicable, etc., none of which require any exceedance of state action levels. Finally, the peelers ask the court to reject the motion based on the public policy considerations and undue prejudice it would cause if landowners, such as the peelers, were required to wait until contaminants exceeded a state action level. Waiting until such an exceedance could create a statute of limitations trap that would leave the peelers and those similarly situated without a legal remedy against the responsible polluting parties. And here that trap is even more vexing because no state action level even exists for the salt or bioaccumulative metals contamination caused by the coal companies, coal ash and wastewater. And just a quick word on the burden. This is a no evidence summary judgment motion, which is essentially a motion for directed verdict. If we as the non-movement present evidence that reveals more than a scintilla of probative evidence on a challenged element of a claim, a fact issue exists. Just as with a traditional summary judgment motion, the court must take as true all evidence supporting the non-moving party's claim and indulge every reasonable inference and resolve any doubts in favor of the non-moving party. Based on this record, we believe the court must find the coal companies have not met their burden and deny the motion. To elaborate a bit on our arguments, first, exceedance of a state action level for a chemical of concern is not required to demonstrate harm to real property. Some constituents, such as salts, do not pose a severe enough risk to human health or ecological receptors, such that any regulatory agency in the state of Texas has set a safety threshold. And yet the presence of these compounds plainly can injure real property. We've provided the court a link to the Texas Risk Reduction Rule tables, which points out that there are no state regulatory thresholds for salts because they are, quote, not necessarily of concern from a human health standpoint. But salts emanating from coal ash and wastewater unquestionably have caused significant damage to soils and vegetation on the Peeler Ranch. And this damage is no less real because the state has not elected to set a safety threshold for calcium, magnesium, potassium, etc. The state simply is not concerned with property harm. It is concerned with cancer and mortality risk and presumes a landowner can recover under the common law for harm to real property. For constituents for which the state has set a regulatory threshold for human health, such as toxic heavy metals, elevated levels that fall under the designated state action level may still reduce the value of the property, and that reduction in value is compensable. In this case, the toxic heavy metals emanating from the coal ash are bioaccumulative, so state thresholds are explicitly inapplicable according to TCQ rules. The court asked Mr. Sutherland a direct question. Is there some table that sets these thresholds they want us to rely on? And he failed to answer it. The answer is no. Instead, he pointed the court to unenforceable agency guidance documents. Guidance documents are not agency rules or regulations. This bears repeating. A guidance document is not an enforceable regulation. And the guidance on which they want the court to rely makes that plain on its face. And I will share that with you, Your Honor.
Go ahead.
Yeah, I just have so much open on my computer. Okay. This is the guidance document, Your Honor, that they want this court to rely on for the process they say the appealer should have followed. It says, number one, the purpose of this publication is to promote the development of consistent and technically defensible ecological risk assessments to be submitted under TCQ remediation programs. Again, the Peeler Ranch is not under a TCQ remediation program. And then it clearly says, this guide is not itself a rule or compilation. And then further down here, Your Honor, it says, furthermore, nothing set forth herein prevents TCQ personnel from varying from policies contained in herein as dictated by the specific facts and circumstances for an ERA or site. These are not regulatory thresholds. This is a guidance document that even the agency is willing to depart from. The coal company's premise has been rejected by the United States Supreme Court, the Fifth Circuit, the Texas Supreme Court, and the Houston Court of Appeals. The Supreme Court in Atlantic Richfield Company versus Christian, which is at 140 Supreme Court 1335, that was in 2020, held that CERCLA does not prevent landowners from seeking restoration damages under state common law tort causes of action for cleanup that is more stringent than EPA orders. The Fifth Circuit in Stevenson versus DuPont at 327 F3rd 400, which was the Fifth Circuit case from 2003, found that no Texas case has adopted the substantial damage requirement for trespass and held that because the only showing necessary is entry over land by something, Texas law would permit recovery for airborne particles. The Texas Supreme Court in Forest Oil Corps versus El Ruccio Land and Cattle Company at 518 Southwest 3rd 422 held that common law claims for contamination are not dependent on the standards of regulatory compliance. And the Houston Court of Appeals in the Mel Acres Ranch case, which is at 389 Southwest 3rd 583, declined to hold that a plaintiff may not prevail against a defendant for contamination without ongoing presence of constituents exceeding state action levels. You need me to stop, Your Honor?
No, I'm scratching my ear. Go ahead.
Okay. All of these cases run contrary to the coal company's argument that the peelers are limited to relief only where contaminants have reached a regulatory threshold. A company engaged in an effort that may cause pollution is subject to both regulatory and common law standards, which are separate. For example, the Texas pattern jury charge defines trespass as an entry on the property of another without having consent or authorization of the owner, A trespass is not excused by the fact that it arises from conduct of an operation that is itself lawful or useful. There is nothing in the definition of trespass that requires a violation of a regulatory threshold when alleging harm from entry of a chemical constituent like salts or bioaccumulative metals. Kiewit has argued in the context of the motions to exclude expert witnesses that the Fifth Circuit's decision in Stevenson was not a rejection of Taco Cabana or Yarborough, but instead an acknowledgement that these decisions were the controlling law. Stevenson was decided in 2003, shortly after those two appellate cases, but well before Forest Oil, which was decided by the Texas Supreme Court in 2017. And even though Stevenson acknowledged Taco Cabana and Yarborough, it did not follow them because Texas law did not set the required levels of air pollutants necessary for recovery under a trespass theory, even though there are, of course, regulatory standards for air pollutants, including particulate matter. The same is true here. Texas has not set required levels of contamination to establish trespass or any tort, and the coal companies in their motion do not point to a controlling regulatory program that allegedly sets an actionable limit. The Fifth Circuit in Stevenson found no Texas case adopting a direct and tangible requirement to prove trespass. The only requirement showing was entry over land by something to be actionable. So the court determined that Texas law would permit recovery under a trespass for airborne pollutants, even without substantial damage to their property. So the law is clear. In Texas, a private property owner may recover in tort for the introduction of waste contamination that has caused property damage or diminished the property's value, regardless of state regulatory thresholds. And I just want to spend a few minutes to give an explanation about how salts, which do not have a state regulatory threshold, harm real property. When salts accumulate in soils, problems arise for two main reasons. The soil becomes less permeable and the salt damages or kills the plants. The first problem is associated with the soil structure. In sodic soils, high levels of exchangeable sodium cause the individual sand, silt, and clay particles to be separated and not clumped together into larger particles. This dispersion makes the soil tight and impervious so that it allows little air, rain, or irrigation water to permeate the soil. So the plants may not receive enough moisture and oxygen to grow, and salts may accumulate on the soil surface because they cannot leach out of the root zone. Plants can also be damaged by salt effects or toxicity. In saline and saline sodic soils, high concentrations of soluble salts reduce the amount of available water for plants to use. High levels of sodium can be toxic to certain plants. Also, the very high soil pH in high salt soils greatly changes the nutrients available to the plants. These high pH levels change the ionic form of many plant nutrients to forms that make them unavailable to plants. More simply, wastewater that contains salts, like oil field production waters or coal ash wastewater, kills microorganisms, kills the seed bank, kills the plants, which changes the soil structure, and the soil erodes away to leave a moonscape. The land is literally gone, and saltwater damage spreads. It gets into the groundwater. Unless it's attended to, the damage just widens over time. And I'd like to show the court a short PowerPoint presentation to make this point better. This is adopted from a presentation made by Carrie Sublett, who is the Sarkis Professor of Environmental Engineering at the University of Tulsa. He teaches a workshop titled Remediation and Restoration of Hydrocarbon and Brine Contaminated Soil throughout the US and as well as Europe and South America. These workshops are attended by state and federal regulators, and he's provided this PowerPoint to me as part of a produced water lawsuit we were in where he was the expert. So I'm cribbing from it to explain the harm.
Your Honor, I'm sorry to interrupt, but Kiewit Mining Group objects to presenting anything that's not included in the peeler's response. This is going outside the record at this point.
This is for demonstrative purposes, so Your Honor can see what happens from salt harm, which they are claiming needs to have a regulatory threshold.
But Your Honor, she's offering it as evidence, if you will, for you to consider in connection with your ruling on this motion. That's not proper.
I mean, if it helps us move along, Judge, I think we would concede that at sufficient levels, salt can cause ecological damage. I mean, that happened when the Romans salted the fields in Carthage prior to the birth of Christ. I think, that is the reason why TCEQ actually does have a PCL process for salt.
In Carthage, I guess time remediated that eventually because it became a large Roman city. All right, Ms. Whittle, I will sustain the objection, but I'll let you go ahead with your explanation. And I have some idea of what you're talking about. I've tinkered for a long time, and I understand that just because there's minerals in soil doesn't mean that they're available to the plants. And I understand that.
Okay, well, Your Honor, some of these are photographs that have all been produced in the case. They're from the Peeler Ranch, so I can. Okay.
Those are fine.
So, Your Honor, this is a picture of the vegetation mortality northeast of the power plant. This shows salt and vegetation impacts that are on the ranch. And this, Your Honor, just shows how salts dissolve in water as ions. Mine water is at the ranch is salty because of the formations that surround the lignite were deposited in a marine environment, and coal ash was disposed in pit. The plant wastewater is salty because the coal ash is stored in ponds, and the evaporation of the boiler cooling water causes salts to concentrate in the wastewater. All of this is in the record. Your Honor, this is where I talked last hearing about where I was present about how salts include more than just table salt. There are different salts, and as you pointed out, a salt is a cation and an anion formed together. And so these are the different ways that spills of salty water can adversely affect plants, as I just discussed. Again, it's more difficult for the roots to extract water from the soil. This shows the process that occurs. It's more difficult for soil to absorb and convey water. And then this shows what happens in a saltwater spill after 3 days, 10 years, you have erosion, 60 years, the erosion continues.
Your Honor, I think we're looking at the slideshow that you just sustained the objection to. The first image we saw was fine. That was of the Peeler Ranch, but I think we're now into the slideshow.
All right, Ms. Whittle.
May I continue, Your Honor?
Well, is this the slideshow that you were asking me to look at?
Yes, I thought I understood you to say that I could present it, but you.
No, I sustained the objection, but I said you could present whatever photographs you had that had been previously disclosed.
Okay, Your Honor. Well, so this particular demonstrative has not been produced, but it shows the levels of salinity on the property, on the Peeler property, that are both in background and then what's present on the property to show why we think there is harm.
Your Honor, we're still looking at the same slideshow.
It's information from this case. I'm not sure I understand what it's.
All right, Ms. Whittle, I believe you said this. You had a slideshow that was from some expert in Oklahoma.
Well, so the slides with the anions and whatever was what I was referring to, because I didn't know that.
Right, now, is this from that slideshow or is this something about the Peeler Ranch?
This is something about the Peeler Ranch.
Okay, then I'll overrule that objection. Go ahead.
So this, Your Honor, shows when you'd have normal soils, that's typical of the topsoil that we are finding the ranges of electroconductivity and sodium in background samples on the Peeler Ranch. But the and the typical range of subsoil electroconductivity and SAR in background samples on the Peeler Ranch are 4.5 feet deep are here in this range. But what we're finding as a result of the San Miguel operations is this is the range of subsoil for electroconductivity and sodium northeast of the power plant. This is the subsoil that remains after their last excavation effort. And so the levels of salt and sodium are far higher than what you would see in backgrounds. And so while there is no set regulatory threshold, we think we can demonstrate it so far exceeds background that it is harmful to the ranch long term. This is also from the power plant. This is only a small portion of this impacted soil has been excavated and replaced. This is the salt crusted soil northeast of the power plant. And the salts that they have removed will continue, even though they've removed a portion of it, what's happening is underneath it will still continue to rise up through capillary rise and continue to harm whatever soil and vegetation they put down. This is at the plant, salt contamination north of the mine pits at the Peeler Ranch, Your Honor. And then this is from our experts, what they believe would need to occur to remediate the soils. The excavation and disposal is not practical for the Peeler Ranch because salinity increases with depth. And so the replacement soils will be recontaminated. And so there needs to be capping and flushing. Now, it's important to recognize that if the coal companies were right, then no one could recover for harm from saltwater spills in the state of Texas. Because again, there are no regulatory thresholds for salts. So a landowner who had a saltwater spill, like from oil field production waters, would be out of luck. There would be no remedy at all for that harm, which could ruin the land permanently. That cannot be the case. There are plenty of such cases in Texas demonstrating the argument is off base. The coal companies rely on inopposite cases that considered a narrow, limited situation, liability of a prior landowner for pollution from underground storage tanks at sites that were already subject to Texas cleanup orders. These cases are not relevant to the counter defendants' polluting activities on the Peeler Ranch. In Taco Cabana, the court determined that a plaintiff who purchased property in as-is condition and was aware that the property was subject to a regulatory cleanup order could not maintain a negligence per se or trespass action against the prior landowner for failure to remove pollutants occurring at levels below the regulatory limits set in the Texas Water Code for underground storage tanks. Taco Cabana involved a regulatory cleanup order and regulatory oversight by the Texas Water Commission, which promulgated comprehensive rules and regulations for the monitoring and prevention of any release of regulated substances from underground storage tanks and the remediation and cleanup of the releases which do occur. That regulatory program no longer exists. Because the contamination levels below the state cleanup threshold did not exceed the applicable regulations, the plaintiff could not recover on the negligence per se claim, nor was the defendant under a duty to remove contaminants below that threshold. The court in Yarborough issued a similar ruling in a case involving a site subject to a regulatory cleanup for a leaking underground storage tank, in which had received a no further corrective action is necessary letter from the TNRCC, which is the predecessor agency to TCEQ. The Easy Mart opinions on which the coal companies rely actually narrowed the Taco Cabana holding, explaining that the plaintiff need not demonstrate contamination in excess of a regulatory cleanup level to a state cause of action level because a wrongdoer is not relieved from liability from such regulations. Unlike Taco Cabana and Yarborough, the peeler's claims do not turn on whether the coal companies committed trespass because they left unreasonable levels of contaminants on the property. The peeler's tort claims are not based on violations of threshold levels of any chemicals of concern. Again, there is no regulatory action level under any state program for the main constituents of concern, salts, that are the limiting factor in remediating the property back to appropriate grazing land for cattle. Nor is there a regulatory action level for any bioaccumulative metals that have also harmed the Peeler Ranch by leaching from coal ash and wastewater. In their motion, the coal companies failed to point to any regulatory threshold or even a specific regulatory program that they contend controls. It wasn't until their reply that they contended the TERP program controlled. Their reliance on Taco Cabana and Yarborough is further misplaced because it ignores the Forest Oil opinion. In Forest Oil, the court held that abrogation of a common law right, as we have said, is disfavored and requires a clear repugnance between the common law cause of action and the statutory remedy. A statute's express terms or necessary implications must indicate clearly the legislator's intent to abrogate common law rights. Your Honor, we submit that cannot be unenforceable guidance from an agency that the agency says even it will depart from. Any relevance of Taco Cabana and Yarborough has been superseded by Forest Oil's express pronouncement specifically addressing Railroad Commission regulations. While Railroad Commission regulations and orders certainly inform the extent to which remediation of contamination is required by law, they do not supplant the defendant's common law duties, which are also required by law. The Forest Oil holding is consistent with long-standing law that compliance with a regulation does not absolve a defendant of tort liability. Because the coal companies have identified no statutory or regulatory language that abrogates the peeler's common law rights, they have not carried their burden and their motion must fail. In fact, they failed even to identify, again, what regulatory program or what state action limits purport to define injury for the torts in this case. So their no evidence motion should fail because it did not identify or establish with specificity what element of the peeler's causes of action they are challenging. None of the regulatory violations the peelers allege under their negligence per se or statutory claim involve specific regulatory action levels for chemicals of concern, which provides yet another material difference between this case and the underground storage regulations at issue in Taco Cabana. Now, San Miguel has entered the buffer zone acreage, a mere fraction of the contamination, into TCEQ's voluntary cleanup program under TERP. This San Miguel remediation does not rely on any TERP regulatory standards, but instead implements cleanup based on visual observation of salt-impacted soils and the geophysical study conducted by peeler consultant Advisian, plus published standards for electroconductivity in soils, nearly an exact parallel to the process of identifying contamination which the peelers used. So even where TERP has been applied to the Peeler Ranch on a voluntary basis by San Miguel, there were no regulatory standards invoked. The only area at issue in this motion is the Peeler Ranch outside the leased areas, but none of these areas are overseen by any regulatory program, although they have been damaged by both the mine and the plant. The Peeler Ranch within the mine permit area is governed by the Railroad Commission's surface mining and reclamation regulations, but none of those regulations purport to set any state action limits necessary to demonstrate tortious harm. Similarly, the leaking coal ash impoundments at the plant are governed by the federal coal ash disposal rule, which includes limits for chemical constituents in groundwater based on the federal drinking water standards. But there's no question those have been exceeded. In prior briefing on the same issue, but not raised in this motion, he would argue that none of the peelers experts had conducted the ecological assessment necessary to derive a chloride state action level. The instant motion argues that the peelers have failed to show contamination over a fixed state action level. But in the reply, however, the motion makes a new argument that the peelers had to derive a protective contaminant limit for salt under TERP. It begs the question, which is it? Is there a fixed state action level, or are the appealers required to derive such a level, which would then serve as the basis for recovery of tortious harm? But of course, the appealers did derive a cleanup level by performing a statistical significant analysis to determine chemical concentrations above background in the sampling results and a robust geophysical survey, all of which is industry standard for delineating waste contamination. In fact, the reply quotes TERP guidance that a chemical constituent, that a chemical of concern concentration for salts should not be high enough to make a natural resource unfit for use. Well, that's exactly what the peeler experts evaluated to design their restoration plan. What is the concentration of salts that makes the topsoil unfit for use as a cattle ranch? We did exactly what they assert we were supposed to do, consistent with the TERP guidance, which again is not an enforceable regulation. They argue for the first time in their reply that the fact that the ecological PCL for chlorides and other salts is site-specific and requires calculation does not make it irrelevant or inapplicable. Fine, that's what our experts did. They determined a site-specific threshold for cleanup based on the same process that's been approved by decades for regulatory agencies. And I want to be very clear, what they are asking the court to do is rely on TCEQ guidance for how to develop a site-specific protective contaminant limit for ecological receptors. A TCEQ guidance document is not a state regulatory threshold. A guidance document does not even have the imprimatur of regulation. The court shouldn't determine that TCEQ guidance somehow changes the standard necessary to demonstrate a common law tort. The coal companies never explicitly argue in their motion that this court should read in the TERP thresholds to common law tort claims involving claims about real property harm. Mr. Sutherland's argument today that the TERP rules control is nowhere in their motion. They raised that for the first time in their reply, which makes the argument untimely. And Kiewit's counsel has already admitted in previous oral argument at the motion to exclude Paul Bowman that the TERP rule does not apply to the Peeler Ranch. Once a release of chemicals of concern has been identified at property unregulated under specific regulatory programs, such as state superfund, underground and above ground storage tanks, municipal solid waste, and underground injection control, the TERP rule controls the assessment and any action taken in response to that release. But none of these programs are implicated at the Peeler Ranch, and the Peeler Ranch is not subject to TCEQ jurisdiction. So counsel for Kiewit was right. This isn't a TERP case. The Railroad Commission does not follow the TERP rule, which their expert, Mark Hemingway, conceded. You will recall the coal companies argue that we should have brought our claims to the Railroad Commission first because of a pervasive regulation scheme. But now they're asking the court to apply TCEQ standards to a Railroad Commission site. It's confusing at best. Also, when it first issued the TERP rule in 1999, the Texas Natural Resources Conservation Commission explicitly recognized that private property owners have independent, additional common law rights that the TERP rule does not reduce or eliminate. Prior to the TERP rule, regulations required full cleanup to background concentrations. Commentators objected that changing to a lesser requirement amounted to a taking and allows trespass and the reduction of private property values. In response, TNRCC explicitly recognized a landowner's right to seek compensation for loss of fair market value, regardless of whether a regulated party may have complied with the TERP rule or achieved a certificate of completion from the agency. We've provided links to the TERP preamble in our briefing, and I previously showed the court that language in the hearing on the motion to exclude Paul Bowman. Notably, Mr. Sutherland skipped that part when he read the preamble today. In addition, Texas law is clear that a property owner may recover for permanent reduction in property value even after every trace of physical harm on the property has been eliminated. Texas courts have established that a property owner may seek damages for cost of repair and permanent reduction in market value after repairs are made. Stigma damages constitute money damage to the reputation of the realty that continues to exist even after the property has been fully repaired or remediated. In their briefing on the motion to exclude Peeler appraisal expert David Bolton, the coal companies mischaracterized the Texas Supreme Court's holding in Houston Unlimited versus Mel Acres Ranch. The court did not decline to recognize stigma damages, but instead merely declined to address the issue of whether such damages are recoverable. And counsel for Kiewit admitted, at least for the purposes of this motion, that stigma damages are available under Texas law. The San Antonio, and in Lucci Terminex, in Terminex versus Lucci, LUCCI at 670 Southwest 2nd, the San Antonio Court of Appeals upheld stigma damages in a case involving repairs to a house that had been damaged by termites and then fully repaired. And the Texas Supreme Court in Mel Acres recognized that its own precedent had permitted recovery of damages for the diminished value of property after repairs had been attempted, but have failed to restore the full value of the property. Here, where there is permanent industrial solid waste disposal, including a deed recordation, along with wastewater mismanagement and contamination on a large amount of real property, prospective buyers undoubtedly will view this property as impaired despite any restoration efforts or promised reclamation efforts. Stigma damages are thus particularly appropriate here in order to make the peelers whole. Because stigma damages are available even after total cleanup, this motion fails. That all by itself means the court should deny the motion. And I will note, for your honor, none of the cases they rely on, Taco Cabana or its progeny, included claims for stigma damages. None of those courts addressed it, except for the Houston Court of Appeals in Mel Acres, which declined to follow Taco Cabana because of the availability of stigma damages. The peelers do allege stigma damages, and the San Antonio Court of Appeals recognized stigma damages, so Taco Cabana simply does not control here. We've used this example in the past, and the court mentioned a riff on the same example today when talking about stigma damages. If someone beats up your car with a bat, the state of Texas may still let you drive the car because it isn't unsafe. But the value of the car is diminished, and a plaintiff should be allowed to recover for cost to restore or loss of fair market value. Now, turning to our second argument, the peelers' negligence per se and Section 85.321 claims do not implicate or require evidence of any regulatory threshold exceedances. None of the implicated regulations discuss the exceedance of a regulatory state action level for a contaminant of concern. And the motion does not identify a single state statutory authority cited in the peelers' negligence per se allegations, which implicates a state action level. The coal companies make a blanket assertion that the peelers' negligence per se claims necessarily include an unwritten requirement of the exceedance of an unspecified state action level. But that's not sufficient to establish they are entitled to summary judgment as a matter of law on this issue. And in fact, it's incorrect. A review of notices of violation for statewide Rule 8 by the Railroad Commission reveals that the Railroad Commission issues those for any addition of pollutants to state waters. They issue them based on visual observation of salt crust, on visual observation, for example, in the Permian Highway spill, of visual observation of particulates in the water.
Your Honor, I'm sorry I have to interrupt again. I object to that last statement by Ms. Whittle. That's outside of the record, and she's testifying.
Ms. Whittle?
Yes, Your Honor. Finally, their theory produces...
Okay, so I mean, I was asking, I mean, do you...
Well, we used the Permian Highway spill as an example in the past, Your Honor, when you asked about whether statewide Rule 8 applies to programs outside of the oil and gas division. And it was an example of a time where they have issued a notice of violation under statewide Rule 8 in the pipeline division. So I was just referring to the same example. I'm not pulling up the notice of violation. My point is just the state of Texas doesn't require an exceedance of a state regulatory threshold, and they have the burden of proving that it does, and they haven't met that burden.
I'll overrule the objection. Go ahead, ma'am.
Finally, their theory produces a perverse result. A landowner whose property was subjected to repeated releases of contaminants would be forced to wait until the harmful chemicals accumulated enough to exceed state action levels before he could assert trespass or negligence claims, which potentially would occur only after some or all of the resulting causes of action were barred by the statute of limitations. Similarly, an alleged polluter could inflict significant harm, but entirely escape liability by ceasing pollution just before the harm crossed the state action level. Requiring an accumulation of property contamination over time could place landowners such as the Peelers in a no-win situation if their claims are unripe when contamination begins, but allegedly past the statute of limitations by the time the contamination meets the regulatory threshold. And here it would be even worse because there are no regulatory thresholds. When exactly would the salts exceed a threshold that is non-existent? The answer is never. Not only that, their position requiring the exceedance of a state action level would be contrary to the applicable law for risk-based regulatory causes of action, which either specifically do not have a statute of limitations or go so far as to preempt any state statute of limitations. Regulatory cases are commonly brought at sites with decades of pollution-causing activity and generally at only the worst sites. The government simply cannot attend to all of the pollution everywhere. Mr. Guthrie pointed to the court to the CERCLA statute of limitation for cost recovery, meaning once a cleanup has begun, the potentially responsible parties have 3 years to bring a claim for cost recovery for the cleanup. But there is no statute of limitation for bringing a claim for violation of CERCLA. That is why CERCLA cases can be brought many decades after the activities causing the contamination. Unlike those regulatory cases, private landowners such as the Peelers are not protected from a statute of limitations defense in the manner that the state or federal governments could be, and therefore must bring their lawsuits in a timely manner. Here, where we have Peeler experts have gone out and created a site investigation that evaluated what the true background level of salts were and have found that there are extreme exceedances all around the property of those background levels. How would they be protected under a statute of limitations claim, having done that analysis, but not met some non-existent regulatory threshold? It just defies logic and imagination. Moreover, Texas law caps damages for injury to real property, where the cost of repairs exceeds the loss of fair market value to a disproportionately high degree, meaning a landowner could never recover for the additional harm the movements say is the threshold for a tort claim. So under their theory, a landowner would have to wait until the pollution accrued to a level to violate a regulatory standard before being able to sustain a cause of action. But then the landowner might not be able to recover money damages for that harm because the cleanup would be too expensive at that point, and their damages would be capped at loss of fair market value. That recovery is often de minimis, especially if the value of the property was not high to begin with. The result of such a perverse scheme would leave landowners with no ability to recover for harm to their property, whether minimal or extreme, and holding the bag on contaminated land. To date, the court has not determined whether the trespasses are permanent or temporary. To the extent the court determines that the harm to the Peeler Ranch is permanent, the Peelers' damages under tort or contract may be limited to a recovery of loss in fair market value, which Mr. Bolton has determined to be $36 million, or about $2 million less than the special commissioners assessed the value in the of the taking in the condemnation case. To the extent the peeler damages are so limited and they have to accept continued possession of contaminated property with a permanent solid waste disposal site, evidence related to the extent of damages that continue to accrue to the peeler property are relevant to whether injunctive relief is warranted. One such measure the court may consider is the cost of ash removal, and you will hear that in one of the other motions set for today, that the coal companies don't want the court or jury to know how much it would cost to remove the ash that was unlawfully disposed. But knowing what it would cost to remove and landfill the ash the companies have unlawfully disposed on the Peeler Ranch puts the loss of fair market value in context. I understand council acted scandalized yesterday by Mr. Bolton's appraisal of the loss of fair market value, but that is dwarfed by what it would cost to undo the disposal of 18 million tons of coal ash that will serve as a permanent source of contamination to the ranch. In fact, the cost of Mr. Johnson's restoration plan plus the loss of fair market value is dwarfed by the cost of removal of the ash, which provides context for the court in deciding whether an award of damages plus an injunction is warranted. I also understand the court is concerned about how future reclamation obligations fit in, but the Peeler's restoration plan does not involve property subject to those obligations. It's focused on the property harmed outside the mine permit boundary. Mr. Bolton's assessment of loss of fair market value was based on the cost of restoration plan. That doesn't include the mine property subject to the reclamation obligations, so there's no double counting. The presumption is built into his estimate that the reclamation would occur because he isn't damaging the property based on the cost of reclamation within the mined area. San Miguel is not under any reclamation or other obligation to restore the property that is harmed outside the mine boundary, which is what we're talking about here. That's not what the restoration and the costs Mr. Bolton considered for his opinions are focused on.
Your Honor, I'm going to object. And we did Bolton yesterday, and we have a lot on the plate today, and it sounds like we're trying to make day late arguments about Mr. Bolton.
Your Honor, their argument is that we have to show regulatory threshold harm in order to prevail on our tort claims. My point is that our fair market value is based on damage to the property that is not dependent on regulatory threshold exceedances. And the argument is that Texas law already.
I'll overrule the objection. Go ahead, Ms. Whittle.
Well, the point, Your Honor, is that Texas law already makes sure that landowners like the Peelers don't end up with a windfall. And so the idea that you have to both wait for a violation to a regulatory threshold and then not be able to recover for anything other than that capped value of loss of fair market value, that is an unfair situation for a landowner to be in. And when you add the statute of limitations on top of it, it's you know, no landowner would be able to recover in that situation. And at this point, the Peelers have land that has no value and is actually an albatross around their necks with no guarantee San Miguel is going to live up to reclamation obligations. And San Miguel may default on its reclamation obligations. Your Honor, and San Miguel has admitted that it will not achieve phase 3 bond release until sometime after 2040, which is more than 3 decades after it stopped mining on the Peeler Ranch. Mr. Peeler is 80 years old. He can't afford to wait until 2040 to see whether they have complied with their obligations and whether the harm that is present now is still present in 2040. And there's no doubt they would make a statute of limitations argument at that point. And just as a last point, Your Honor, the peelers have produced evidence regarding contamination outside the lease boundaries. After 15 years of inaction and allowing the problems regarding wastewater management and seepage to expand, within days of receiving a letter from the peelers in 2018, San Miguel, at the direction of it and STEC's general manager, Mike Kizar, began a series of massive wastewater discharges over the Peeler Ranch outside the lease boundary in an effort to dewater Area A of the mine. Mr. Kizar testified that he knew the wastewater was high in salt and that his rationale in approving the discharge over the Peeler Ranch outside the lease boundary was it was the most expedient way to get rid of that water. Now, as set out in Mr. Gordon Johnson's declaration, San Miguel's discharges of industrial wastewater and other liquids directly onto the Peeler Ranch, including that area north of Pond 7, have resulted in a zone of high terrain conductivity that coincides with the area of vegetation stress and mortality. The areas affected by the discharges of the mine water outside the lease boundary are essentially void of vegetation and are covered by a layer of salt and other chemical precipitates that, in Gordon Johnson's opinion, are the direct result of those mine water discharges. In addition, the declaration Anthony Brown lays out in detail San Miguel's history of the water management issues in the mine, which has resulted in seeps, groundwater pollution, and damage to the soils and vegetation on the Peeler Ranch outside the lease boundary, and describes the site investigation process, results, and the recommended remedial plan to address the harm. As the evidence shows, there is ample evidence of tortious harm outside the leased areas of the Peeler Ranch, and this evidence is undisputed in the record. Now, to address the objections to the declarations submitted by Mr. Brown and Mr. Johnson that we incorporated into our response. The parties don't seem to be objecting on the basis that we didn't attach them, which was a technical issue. They're very large, and we've now submitted them 3 times to the court. They're in the record, and under Lance versus Robinson, the Texas Supreme Court specifically held that a party can rely on summary judgment that is on file at the time of the hearing, even if not attached to the response. Everyone has these declarations. The court has them in the record 3 separate times, both in response to STEC's motions for summary judgment and in the response we filed to the motion to reconsider the ash disposal motion for summary judgment, which was filed earlier this summer, but then San Miguel pulled the hearing. It has been reset until January. The coal companies appear to argue that experts cannot produce affidavits after the expert deadline, but there are 2 problems with that argument. First, in just the last 2 weeks, the court has seen at least twice for the coal companies' experts, William Meister and also Mark Hemingway, that counter defendants submitted new affidavits for their expert witnesses after the discovery deadline with new information not provided in their expert disclosures. And second, the argument regarding surprise or unfair prejudice is not persuasive. Not only were these declarations filed with the court in September, the Brown declaration has been on file since at least July 2020 in response to the ash disposal motion for summary judgment reconsideration. And the Johnson declaration was part of the condemnation proceeding even before that. Their arguments that the declarations contain conclusory statements, new opinions, and other alleged problems should also be rejected. The parties have seen these declarations on previous occasions and never objected to them. They also reiterate opinions all disclosed in our expert reports and depositions. We can't submit expert reports as summary judgment evidence, nor did we depose our own experts. So we have to submit sworn declarations from our experts. That's how folks normally respond to motions for summary judgments. Those declarations simply summarize information disclosed in their reports and depositions, and nothing Mr. Guthrie went through was new at all. The argument that we shouldn't submit sworn declarations from our experts to respond to motions for summary judgment is strange. How are we supposed to presuppose we needed these declarations to unknown motions for summary judgment at the expert disclosure deadline? And it's important to look at the purpose for which these declarations are being offered today, which is to demonstrate damage outside the lease areas. The fact that they don't address state action levels doesn't render them irrelevant. And in any event, even if the court does decline to look at those declarations, we have the testimony of Mr. Kezar, which demonstrates he ordered the release of the wastewater outside the lease area and knew it contained harmful levels of salts, but did it anyway, which provides more than a scintilla of evidence on liability and harm on all of our tort causes of action. By contrast, Your Honor, they have attached several unsworn expert reports as exhibits to their reply to their no evidence motion for summary judgment, which they filed late last night. We filed objections to that evidence and asked the court to strike it as both untimely and hearsay. The coal companies have failed to demonstrate that an exceedance of a state action level is an element of the peeler's claims for trespass, negligence, negligence per se, and Section 85.321 violations, thereby rendering summary judgment inappropriate. We've presented sufficient evidence to meet the summary judgment burden, particularly when viewed in a light most favorable to the peelers, and the peelers respectfully request the court deny the motion for summary judgment on the peelers' remaining tort claims. Thank you.
Okay, Mr. Guthrie.
Your Honor, I wonder if Mr. Sutherland wouldn't like to go
Oh,
first.
I'm sorry. I'll let him go first. Yes, he started this. It's been a while.
Yeah, it has been a while. So, Judge, we heard a lot in that presentation. A lot of it was not relevant to our motion. You know, the discussion about salt causing contamination to soil, it can cause impacts to soil. As I said at the time, you know, that's at some level, that's definitely true. There's a lot of discussion about stigma. There was a lot of discussion about various historical information on various releases. I'd like to bring the court back to what this motion is actually about. And I would really like to focus the court on the first issue that we asked you to address as part of this motion. And that is it the law in the state of Texas, and particularly within the San Antonio district, that in order to prove a tort, whether it's statutory or whether it's common law, for environmental contamination, that you have to show an exceedance of a state action level? I'd encourage you to go back and look at the cases because what I heard from Ms. Whittle is not what the cases say. First off, I've just got 3 of them here that I want to point out to you. Forest Oil does not say what she says it says. It is a case about the Texas Railroad Commission potentially, at least one party was advocating, abrogating a party's right to bring a common law claim. That is not what this case is about. This case is about, has the state of Texas set the minimum level for a common law claim? And those are 2 completely different things. And Forest Oil doesn't address any of this prior case law. The other thing I'd ask you to go back and look at specifically is go back and look at the Easy Mark case. She says that case narrowed the rule so that you don't have to exceed a state action level under the state of Texas in order to prove a tort for environmental contamination. It does not say that. It says the exact opposite, Your Honor. It endorses Taco Cabana and Yarborough and the other cases and says this is the law. Now, you know, it says that contamination doesn't have to be on the adjacent property. It just has to be on your property, which was, in this case, a third-party property where the release did not originate. And then the third case I would ask you to go back and look at is with respect to her negligence per se argument. She makes the negligence per se argument that none of these regulations or statutes specifically addresses state action levels anywhere within the regulation or statute. Well, go back and look at Taco Cabana. Taco Cabana asserted a negligence per se claim. The negligence per se claim was based upon the defendant's failure to properly monitor its underground storage tank. That's not a state action level regulation, but nevertheless, the court determined at least implicitly, that was a regulation that was designed where its protected interest was either to prevent or to remediate environmental contamination. And that's the protected interest that's at issue in these negligence per se claims. And the Taco Cabana opinion is directly opposite of what Ms. Whittle just told you. The second thing I would like to raise in my response is all of what we just heard depends upon Ms. Whittle's argument that there is no state action level for salt. She said it, if she said it once, she said it 100 times. There is a state action level for salt. It just needs to be derived based upon the regulations under TURB. We had a little bit of a discussion when I was talking before, Your Honor, and I was trying to think about how to convey this point. But, you know, if you think about, as an analogy, think about income taxes, right? Your income taxes are not the same as my income taxes, but there's a federal program that specifies how much money each person is going to have to pay in income taxes. And they may have to look at their, you know, whether they have rental income, they may have to look at how much money they pay for mortgage interest. They may have to look for, you know, how much money they give for charitable contributions, but there's a process that ends up with a number for every single one of us. Just like there's a process that ends up with a protective concentration limit or a state action level that applies to somebody in Port Arthur. And there's a different one likely that applies to somebody in Fort Worth because the ecological issues are different, but the process exists. And it doesn't just exist in guidance documents. I showed to you as part of my original presentation, the TURP rule. And if you look at 30 Texas Administrative Code, section 350.77, the specific regulations related to the calculation of PCLs for ecological receptors are laid out right there. It's not a guidance document. It is a regulation that was subject to a proposed rule, comment by the community, and final regulation promulgated by the TCEQ. Let me see. I've got on the pictures she showed you are from the buffer zone. That map that I showed you at the beginning of this presentation, we're talking about things that are outside of the leased properties. That cleanup that we did, that was a voluntary cleanup within the buffer zone. What we're talking about is stuff that's outside of the leased properties, whether it's the buffer zone or whether it's the mining lease. And all that stuff is irrelevant to this motion because we're talking about the tort claims, and those are the only tort claims that are left, are the ones that are not covered by contract based upon your ruling on economic loss. And then one final point on the affidavits that we submitted with our experts, those only went to qualifications issues. Absolutely, everything. They only went to qualifications issues. The peelers made a bunch of arguments about our experts having, you know, particular specific qualifications. You may remember with Hemingway, there was arguments about stuff about whether or not he could read aerial photographs. That's not something that normally ends up on your CV. It wasn't covered in his deposition. We were filling in the record with respect to those things on qualifications. None of that is new opinion. And I think the distinguishing thing here that Mr. Guthrie covered quite well in his original presentation is that what we're really objecting to here is the fact that they're introducing brand new opinions, you know, 6 months after the expert deadline for reports. So, I mean, I think that those are the big things, unless the court has additional questions. I mean, I would encourage you to go back and look at the cases, particularly on the question of law issue. That's the first question that we asked you. And with respect to this idea that there is no PCL for salt, there is no state action level for salt. I mean, I can't tell you the number, but I can tell you there is one. It requires work. Work that the plaintiffs were supposed to do that they did not do. That's all I have.
Your Honor, I have a short response if Mr.
You're right.
Guthrie.
Actually, let Mr. Guthrie go first, but let me ask Mr. Sutherland. Should it be clear cut if the court's going to find that the legislature is preempting common law rights? Should it be clear cut that that's what the legislature was trying to do?
Well, I don't think that, the court is ruling that the legislature is preempting common law rights. I mean, because the common law causes of action still exist. I mean, the peelers can bring a claim for trespass. They can bring a claim for negligence per se. And that common law claim, as part of it, includes some measure of showing that there was damage, some measure that they were showing that there was a breach of duty. That's already part of our common law, Your Honor. And we devise ways to explain to the jury how particular actors, whether or not they reach the level that crosses over the line on those tests. And the fact that a judge may set that test in an opinion that we then apply as part of our jury instruction, that's one way to do it. But another way to do it is to do what the San Antonio Court of Appeals did in Taco Cabana, what the trial court did with the JNOV that they issued in that case was, I'm going to look to the expert that is setting these standards as part of a regulatory scheme set up by the legislature. And I'm going to look to those experts to come up with a uniform level that can be applied across the state, or at least a uniform process that could be applied across the state. That's not the legislature's coming in and stepping and replacing a judicial prerogative. That's just finding a threshold that makes the most sense to implement the intent of that particular cause of action.
All right, but for chemicals of concern that don't have a state action level where you have to go through a process of calculation, I understand that if there's some state action level that's published and you can go and look it up, that lets people know what their rights are. But what you seem to be advocating is a process to where you don't know what your rights are until you go and spend a huge amount of money having an ecological study done, and that industrial operations are free to pollute to their heart's content until someone proves that they're polluting too much because there's no fixed standard. And shouldn't it be the other way around? If you are out there putting pollution out as an industrial concern, shouldn't you have the burden of showing that you're privileged to do so under the law?
Well, I mean, I think what we're talking about here are two different things. I mean, I think in terms of as a regulated entity, clearly you have the burden to go out, get the permits that you're required, and to operate within those permits, and deserve the privilege that the state is giving you in running your business. But what we have here is sort of the opposite of that. We have a homeowner coming to an entity that has those permits and is operating under those privileges and saying, you know what, you've done these things that we think are wrong. And under those circumstances, it's the party coming to the industrial entity and saying, hey, you've hurt me, you've hurt my property over here, to meet the standard that the state has set out of what represents an injury. And the TCEQ, I mean, has developed these rules. And if you look at the rule that I provided to you, it's very long and it's very detailed, but it just like the tax code, it tells you what your level is going to be.
Okay, Mr. Guthrie.
Thank you, Your Honor. I'll try to be as brief as possible, but let me address the question you asked a minute ago, which was, should it be clear that that the legislature was preempting the common law rights? And correct me if I'm wrong about that, but I think it's pretty clear cut in Taco Cabana and the Easy Mart cases that is what occurred. And I don't know that there needs to be much more indication of that's clear cut. And I think that's the legal standard that applies. I want to address some of Ms. Whittle's points. She was talking about the burdens on a no evidence motion for summary judgment and presuming all facts in favor of the non-movement and scintillas of evidence and the like. What she was referring to was the standard to create a fact issue that precludes summary judgment in a no evidence motion. And the appealers have not met that burden here, because if you agree with the question of law, the proposition of law that we assert that somebody needs to prove a violation of a state action level, and we use that term generically, by the way, that could mean something on the list. It could mean something, a level that's determined under the PCL rules. I'll elaborate more on that in a minute. But they have the burden, if you agree with that proposition of law, that somebody needs to prove a violation of a state action level to be able to recover against somebody for pollution, then the fact issue that could get created is whether or not the appealers have brought forth any evidence of an exceedance of a state action level that applies. And the answer to that is clearly no. They have not, and they admit that they don't. So what it boils down to is this is really an issue of law for the court to decide, this no evidence motion for summary judgment, because I don't think there's any dispute that there's no evidence of any exceedance of a state action level related to property outside of the mining lease or the buffer zone lease. Let me next
And
turn.
is it San Miguel and Stex and KMG's contention that all of the saltwater damage we've seen pictures of, where you have salt encrusted on the surface, that's all on the lease premises or in the buffer zone?
The pictures that we've seen today, I believe, are within the buffer zone, Your Honor. I mean, I don't know if I can answer that question generically as to any pictures I've ever seen, but based on what we saw today and Ms. Whittle's discussion about the remediation program that San Miguel had undertaken, that is on the buffer zone. And I believe it is all contained within the buffer zone.
All right, go ahead, sir.
All right. Ms. Whittle said that a Kiewit lawyer in the hearing on KMG's supplemental motion to exclude Paul Bowman said on the record that he admitted that TERP rules did not apply. And that's not exactly what he said. And that's not even what the appealer's response says. And I'm referring to page 15 of the appealer's response and footnote 12. What my co-counsel, Cody Schneider, said is this is not a TERP case, and this is certainly not a CERCLA case. And by reference to the TERP case, what he meant was it was not an enforcement action by or under TERP, not a regulatory enforcement action. And so KMG has never admitted that TERP rules don't otherwise apply. Ms. Whittle argued that this argument about protective concentration limits only came up in connection with the reply. The reason for that, the reason those words were not used in the motion is that we refer to state action levels as applicable, the things on the lists that we've looked at and the things that are determined based on the determination of a protected concentration limit. Now, the reason why the protected concentration limit started being discussed in the reply is the Peeler's response, which said, you haven't told us which standards apply and where. And so then in the reply, we explained, here is where the standards come from. So the motion covered the point. I disagree that it was first raised in connection with the reply. It has always been in there. Let me turn to forest oil next. I am frankly astonished that the Peelers continue to argue about forest oil. And I've sort of resisted raising this the last few hearings where forest oils come up. But my firm tried forest oil and it also participated in the appeal. But one of Ms. Whittle's attorneys who was working on this case was also involved in that case. And they should know that there was no issue about state action level involved in forest oil. It was a dispute over the exclusive jurisdiction of the Railroad Commission, or not, as the court held, that the Railroad Commission in that case, which involved a dispute over oil and gas activities, was not subject to the exclusive jurisdiction of the Railroad Commission. Has nothing to do with this case. If you look at the appellate briefs in the Supreme Court, there's no discussion about state action levels or anybody making a contention that a state action level governed the underlying claims that the landowner in that case was making. So forest oil is a non-issue. I just encourage you to read it and put it to bed. Next, the Peelers argue very forcefully that there's no requirement that a state action level violation or exceedance be demonstrated in order to recover on a tort or a statutory tort claim. But they cite no Texas case that stands for that proposition because they can't, because there's not one. I hope Your Honor considers that in the context of the argument that you heard, because Ms. Whittle made it very forcefully, Texas law does not require, etc. Well, no Texas case supports that. The Texas cases support the state action level. And the cases, as Mr. Sutherland pointed out, I don't want to plow that ground. The Fifth Circuit cases, the other case, and this is in our briefing as well, have nothing to do with this issue. CERCLA has nothing to do with this issue in terms of whether the state action level applies. Now, Ms. Whittle also represented that I admitted for purposes of this motion that stigma damages are recoverable under Texas law. I don't think I did any such thing, and I can't leave the record as is based on that assertion. Let me look at my notes here. I'm going to wrap this up. as to the motion to strike and to exclude the late filed declarations, I defy the appealers to demonstrate to you, Judge, where these new opinions in these declarations were contained in their 20,000 plus pages of expert reports that were timely filed. They are not. They didn't express causation opinions in the way that they did here. It's just not true. These are new opinions, and they've certainly not gotten into the record in any case in which KMG was involved in terms of being a party to the motion or the respondent to the motion. But irrespective of that, these are new opinions. We object. My recollection is similar to Mr. Sutherland's, that the San Miguel experts who had affidavits submitted in connection with the motions for disqualification related only to qualifications, and they were not providing new opinions. So I renew the request that the court not consider the Johnson and Brown declarations or Ms. Whittle's argument based on them, where she said that they were provided as evidence of damage to areas outside of the leased property. And again, that's not really germane to the motion. Damage outside the leased property, except to the extent that they can show that they violated a state action level, or that there was a violation of a state action level that regards property outside of the mining lease and the buffer zone lease. So in summary, KMG requests that the motion for summary judgment be granted. Again, we think it's a clear point of law that frankly the appealers have no contrary authority for. Thank you, Your Honor.
Okay. I
Your
guess,
Honor.
Bill, any last points?
Yes, Your Honor. If the court determines that TCEQ unenforceable guidance on how to derive protective contamination limits is required to be followed in order to establish a tort for property harm, then our expert declarations have established a fact issue as to whether they followed a process that TCEQ would approve of. Comparing to background levels is a long-standing approved of process that is allowed under TURP and is often followed under TURP. So we think that to the extent the court wants to incorporate unenforceable guidance into tort requirements, we've raised a fact issue as to whether our experts' analysis would have been approved by TURP had we been under some sort of TCEQ cleanup program. But again, we are not under a TCEQ cleanup program, so there's no regulator overseeing this to approve anything. And TURP does not apply to the site. San Miguel's own expert, Mr. Hemingway, testified to that. He also, this argument about the need to derive limits following TURP guidance was not raised until the reply. In fact, in the opening motion, there's no effort to say what regulatory program provides the limits that they say we should have followed. If Your Honor reads their motion, there's no reference to TCEQ, There's no reference to the Railroad Commission. There's no reference to TERP. There's no reference to the federal coal ash rule. All of those have different limits that may be applied to the site in different ways, and they didn't argue which one should be followed until their reply. And their argument is that we should derive a limit to protect against ecological harm or change in use of the property, which of course is exactly what our experts did. And then I just want to follow up. Mr. Guthrie said we haven't shown any case law to demonstrate that courts find trespass and negligence without protective contaminant limits under a regulatory program. That's not true. We cited many cases in our response where courts have found harm for produced water releases, which again, there are no regulatory standards for salts. And I think if the court wants additional briefing on that, we can find lots and lots of cases. And I just want to point out, Mr. Sutherland said something backwards. While the economic loss rule motion held that we could not bring tort claims within the lease property, which we're asking the court to reconsider because the economic loss rule has never been applied to real property damage cases. The court never has ruled, and no one has ever argued, that the peelers can't bring claims for damages for breach of contract for property outside the lease boundary. If they have harmed property outside the lease boundary as a result of breaches of the contractual obligations, those would flow from the breaches. And so no one has raised that argument. Mr. Sutherland suggested today that somehow contract damages wouldn't extend outside the lease boundary, and that's never been before the court. And we disagree with that. So I just wanted to point that out. Thank you, Your Honor.
All right. It's 2:30. I don't believe that we have a time to start anything else. So what do you want to do with the rest of the motions?
Your Honor, I think we probably don't have time to get to anything. We can work with Ms. Riley to reset them.
Okay. All right, then. And what do we have set next week?
On Monday, the motions to exclude Anthony Brown and Gordon Johnson will be heard.
Okay. And do the attorneys want to talk among themselves about whether whatever rulings are made on some of the issues that have come up this week, do you want to talk among yourselves about an agreement to take them up in an interlocutory under Rule 28 point whatever it is? I don't know if you want to face having to do something twice or if you had some clear resolution from the Court of Appeals about what the standard would be, if there's disagreement, if that would bring you closer to a resolution. I'm sorry, specifically on state action levels. What came to my mind? On state action levels and possibly also on, I guess, damages. We can certainly talk offline about that. Just think about it. I don't know. Okay. All right. I will see you all next week then. Thank you, Your Honor.
Thank you, Your Honor.